Okay, Mr. Hunt, are you ready? Mr. Warner?
Yes, sir.
Okay. Good morning, everybody. The time is 10:05, and I call the September 8th, 2022 Planning Board meeting to order after our August recess. It's good to see everybody again. We have the following board members with us. We have Commissioners Washington and Commissioner Dorner, and I am Chair Shapiro, and we have our quorum. Moving forward to the business at hand, please note that the deadline for all participant pre-registration and for all submission materials and exhibits was 12 noon on the Tuesday before this planning board meeting. Deadline is shown on the screen, and it is announced in every weekly meeting. It's posted on our website, clearly stated in a number of different forms. Registered speakers may join the meeting with the link provided in the email, which is provided by the planning board office, or you may listen by phone by utilizing the call-in number provided in the email. Of course, anyone may tune in to watch the planning board meetings via live stream. If you wish to speak or become a person of record, you may use our online web form, which you see on the screen. In addition to the commissioners, we are joined by our Deputy Planning Director, Derek Berlage, David Warner, our Principal Counsel, Jessica Jones, Planning Board Administrator, Marie Proctor, who is our Senior Technical Hearing Writer, James Hunt, Division Chief, Development Review Division, and we also have staff members Kenneth Flanagan, who will be guiding us through the exhibits, and Ryan Crown, who's our technical guru behind the scenes. Thanks to everybody, and again to everybody, welcome back after what I hope was a relaxing and enjoyable August recess. Not an August recess from Planning Board. I know it was not a recess from work, but it's good to have everybody back. So we'll now begin the meeting. We have the first item that we have is a resolution of appreciation for Adrian Gardner. Now, we actually had Mr. Gardner, our retired general counsel, who came before us, but we have the official resolution that we wanted to approve as well. So I'm not going to go through and list all of the wonderful things that he's done again, which we did the last meeting, and provide all the accolades as well. But I do want to make sure that we formalize this resolution of appreciation. So unless there are any questions or comments from board members, I would look for a motion to approve the resolution of appreciation for Mr. Gardner.
I move approval, Mr. Chairman.
I'll second.
Okay, we have a motion and a second. Again, there'll be a retirement party for him coming up later, so there'll be plenty of opportunities for us to connect with him as he moves on to his next adventure. So there's a motion and a second to approve the resolution. If there's no discussion of the motion, I'll call the roll. Commissioner Washington?
Vote aye.
Commissioner Dorner?
Vote aye.
I vote aye as well. The ayes have it, 3-0. Thank you all. So moving on to the next item, is a motion to approve the draft minutes of July 28, 2022. Is there a motion?
Move approval, Mr. Chairman.
I'll second.
Motion is second. If there's no discussion, I'll call the roll. Commissioner Washington?
Vote aye.
Commissioner Dorner?
Vote aye.
I vote aye as well. The ayes have it. For the motion to approve the draft minutes of July 28, 2022. So next item, we're going into executive session. Let me read this statement and look for a motion from you all after I read the statement. The statement is we're going into executive session pursuant to the general provisions articles of the Annotated Code of Maryland, Articles 3, 305, subsections B3 and B1, 2, to discuss two issues: acquisition of real property for a public purpose and matters related thereto, and for the purpose of protecting the Commission's negotiating position and to discuss a personnel matter. So that's the reason why we will be going into executive session. Is there a motion to go into executive session?
Move approval.
Second.
Motion is second to go into executive session per the statement read as well. If there's no further discussion, I will call the roll. Commissioner Washington?
Vote aye.
Commissioner Dorner?
Vote aye.
I vote aye as well. So we'll go into executive session and we'll be back in open session. My guess is we'll be back in open session within 10 or 15 minutes tops. Okay, so commissioners, we will switch platforms. Folks, we are back in open session. We'll give ourselves a minute or two for folks to gather. Took a little bit longer than we thought, as is often the case in our world. Okay, we have our commissioners. Are you ready for us? Okay, all right. So we are now back in open session, out of executive session. Our first action back in open session would be a motion to ratify the actions that we took in closed session. Is there a motion?
So move, Mr. Chairman.
Second.
The motion is second to ratify the actions taken, two actions taken in executive session. No further discussion. I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote as well. The ayes have it, 3-0. Thank you all. Next item on our agenda. Bear with me one sec. So we're with our consent agenda. We have items 4A and 4D for approval. Is there a motion to adopt the consent agenda?
Move approval, Mr. Chairman.
Second.
Motion is second. No discussion. I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it to adopt the items in the consent agenda. Bear with me while I thumb through. Okay, item 10. Item 10 is this is onto the regular planning board agenda. Item 10 is an update to transportation review guidelines supplement. We'll have a staff presentation. I think we have a couple speakers signed up as well. Let me turn it over to staff for the presentation. We have Mr. Capers and Ms. Smith. We can't hear you, Ms. Smith. Mr. Capers?
Yes, good morning, Mr. Chair. Can you hear me?
We can hear you. We can't hear Ms. Smith.
All right, Ms. Smith will try to reboot her computer. If you could give us a few minutes, a couple of minutes.
I think this is yes, no problem. And I would say more holistically, there's something going on after the August recess where we're having technical issues all over the place. So as we all get back into the swing of things. So no problem. Take your time, Ms. Smith. I am. Hold on a second.
Able to hear me now?
I think I may hear you.
Yeah. Audio's coming through.
Did you hear me?
Yep, we can hear you now. We can't see you anymore, but we can
They
hear
can
you.
hear me. Yes, they can hear me now. Okay, great.
There we go.
Sorry about that.
No problem at all.
Okay, so good morning, Mr. Chair and members of the board. For the record, Noel Smith with the Transportation Planning Section. As you may recall, the Planning Board approved the Transportation Review Guidelines 2022 supplement in May of this year. The supplement was approved to align with the new zoning ordinance and subdivision regulations that came into effect in April. The item before you today proposed minor technical edits throughout the supplement document, in addition to revising Section 2, requirements and findings for various application types, to include the special requirements for the Central US 1 corridor. These special requirements are included in the adopted and approved Central US 1 Corridor Sector Plan, as well as the Transportation Review Guidelines Part 1. In the adoption and approval of the updated supplement document, the transportation adequacy requirements for the US 1 corridor were not included. While staff has continually applied these standards to development applications opting to use the prior regulations, it was also determined that these standards are also applicable to applications using the new regulations. Therefore, TPS is recommending adding this criteria to the 2022 supplement document for consistency. The memo that you were provided details all of the revisions and language we are recommending. And with that, I'm here for any questions.
Thank you. So there are questions from board members, but actually before we do that, there's been some concerns expressed about this by some folks in the community. I think Mr. Haller, Mr. Leonard may have had some concerns. This is not a public hearing in any traditional sense, but I'm wondering if we want to hear from them, if you have any concerns or questions about what staff has presented, I can allow them the opportunity to have a few words, and then staff can respond, which I think will help educate us around this if there's any concerns or questions. So if it's okay with you all, we could ask Mr. Haller, Mr. Leonard, if they're on the line, if they want to come on and say a few things just to play this out a little bit. I'm actually fine either way, board members, whatever you want to do.
I'm fine with hearing them, Mr. Chairman, especially because we have in the record a citizen exhibit that I believe one of them submitted, so that's fine with me.
Yeah, I think in the notion of like transparent governance, it's helpful to get feedback from the public when we're doing things, because sometimes we could miss something that's important that we're just not thinking about. Hopefully that hasn't happened in this case, but I think it's worthwhile at least hearing them.
I agree with both of you, and I'm confident with staff's position on this, but I think why not just hear from folks if they have some concerns and we can help make sense of it. So, Mr. Haller, Mr. Leonard, are you on the line?
I am, Mr. Chairman.
Yes.
Okay, so let me just give you a couple minutes if you have something that you want to say around this matter, and then I'll turn right away unless we have questions and ask staff to respond to it, just so we can make sense of it. But Mr. Haller, take it away.
Sure. Thank you, Mr. Chairman, members of the board, and thank you for the opportunity to speak briefly this morning. And I will be brief. Let me just provide some context to the supplemental materials that we submitted for your review. Mr. Lenhart and I, as well as a couple of other land use attorneys, have been working on cases in the Route 1 corridor for years, and have been working under the policies and guidelines that were set forth for conducting traffic studies in the corridor throughout the better part of the last 20 years. And as the board is aware, those guidelines and modifications have resulted in a tremendous amount of quality development along the Route 1 corridor. We have been experiencing within the last month or so some what we believe to be dramatic and substantial changes in the policy of how traffic studies are scoped and how the requirements are applied. And when we heard that this was being put before the board's agenda, we were concerned that staff was trying to formalize a change in policy that would have a negative impact on development within the Route 1 corridor. And so we had a meeting with Mr. Berlage, and he indicated that the guidelines that were being inserted into the transportation review guidelines, in other words, the matter before you today, was identical to what was in the 2012 guidelines. And when we went back and we compared the two, we found that there was language that was not inserted in the guidelines that are being placed in the 2022 supplement that was in place in the 2012 guidelines. And so I provided as backup a revised document to reinsert that language. as we were concerned that removing that language was intended to suggest a policy shift on the part of staff. We had a conversation with Mr. Capers and Ms. Smith and Ms. Schulers earlier this week, and they assured us that that was not the case, that the reason that the language was removed from the 2022 supplement is because it references the development district, which no longer exists under the new code. And we understand and do not object to that removal of that language and that shift. They also informed us that there is no intention to change the policy per se that is listed in the standards, but that they are evaluating the appropriate method by which studies are scoped. And we're continuing to work with them on that issue. And we're hoping that we can continue that dialogue and follow up with them. But that just wanted to provide the context of why we submitted the revised language, because we were attempting to make sure it was identical. But as I mentioned, they were very clear that the removal of the language wasn't an intention to indicate a shift in policy, but was really intended to reflect the fact that the new zoning ordinance removes the development district, and that language needed to be removed. So we do not object to the language at this point that staff is proposing for the 2022 update, but we are concerned about and are continuing to work with staff on how these traffic studies are scoped going into the future.
Mr. Berlage, you want to respond to that, unless you want to have your team do it, whatever you decide.
No, I think I can respond very quickly by saying that Mr. Haller has exactly and correctly described the situation. And so the guideline changes that are before the board today, as Mr. Haller indicated, do not resolve his question one way or the other. His question has to do with how we scope traffic studies when applicants submit applications for preliminary plans. And as he indicated, we have an ongoing discussion with him and his colleagues about those interpretations. And we will continue that discussion. But the action today does not in any way foreclose the goal I believe Mr. Haller has of continuing a conversation about which intersections are included for US 1 projects.
Okay. Mr. Haller, anything else you want to add? Is Mr. Lenhart on the line?
My comment. Thank you.
Okay. All right. Thank you, Mr. Berlage. Mr. Lenhart, you are there. Is there anything you want to add, or we're okay?
Yes. Good morning, Mr. Chair. I would like to simply align myself with Mr. Haller's comments. I don't want to belabor the issue. I've been involved in nearly 20 projects along the US 1 corridor over the last 20 years. And we were simply concerned that this action may change the policy direction. And after conversations with staff, we've been assured that this document will not change the policy, and we will continue working with them on the scoping of studies going forward.
Okay. Thank you. Thank you, Mr. Lenhart. So, board members, any questions for staff or any reactions to what you heard from Mr. Haller and Mr. Lenhart, or we're good to go?
Good to go.
I just want to thank them for engaging with staff. That area is really hairy. We've had pedestrian fatalities on Route 1 in the College Park area, south of Campus Drive, and then up in the Cherry Hill area that is being touched in here. You can't walk across very safely across Route 1. So continued engagement with the transportation experts out in the community to offer safer ways for pedestrians and others to access that area and for vehicular traffic to navigate it is certainly a good thing to do.
Thank you. Thanks to both of you. And thanks to staff for all your work on this and to stay in dialogue with folks in the community as well. It's very helpful. So is there a motion, unless there's anything else before us in this, the motion would be to approve the update to the Transportation Review Guidelines supplement as presented by staff and recommended by staff.
I move approval, Mr. Chairman.
1 second.
Motion is second. No further discussion. I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Would I?
I vote aye as well. The ayes have it, 3-0. Thanks again, everybody, for this. Hey, I neglected to read through the order of the agenda, I believe. I did not do that, did I? All right, so let me read through. It's a bit of a convoluted order, but we just took up item 10. So we're now going to we're going to proceed in this order. Item 10, which we just did, then items 8, 9, 5, 6, 7, and then 3A. Okay, so 10, 8, 9, 5, 6, 7, 3A. That'll be our order for today. So we just completed item 10. We're now going to item 8. Item 8 is a request for a reconsideration hearing for preliminary plan of subdivision. We actually have 2 requests for reconsideration hearings for preliminary plan of subdivision for the same preliminary plan, but we're going to take them up as separate items. And so we'll have different speakers on each one. There may be a little bit of lack of clarity about who signed up for which one. I believe we also are going to hear a little bit of concerns about one of the items. I believe one of the attorneys neglected to sign up, and our rules are clear. So he has not signed up. He will not have the opportunity to speak, but there'll be other people who speak as well, I'm sure. So the first item is item 8. Again, request for reconsideration for preliminary plan of subdivision 4-21047, Chance Academy. We have, I'm going to turn to staff first if they have any brief comments on this, Ms. Gupta. And then I'm going to turn to one of the people who has requested the reconsideration. That's Ms. Kirkland. I believe she wants to take about 10 minutes on this item.
Yes.
And then okay. And then if there's other folks who've signed up who also are aligned with her, we'll give them a chance to speak. And then we will turn to, I believe we have Mr. Taub, who will be representing the applicant on this, who will respond as well. The one thing I want to say about this before we get into the speakers.
Chair Shapiro, I just,
yeah.
Sorry, I apologize. Ms.
I want to get
Kirkland's
into, yeah.
Ms. Kirkland's reconsideration request is item 9. So that may be the item that she wishes to speak 10 minutes on. If you want to let her speak on number 8, that's fine as well. But I think her request is number 9. So the first one you're considering is 8, is the request from the FCA, the Community Association.
Okay, Ms. Kirkland, so you're going to be speaking. I understand they're the same items, but we have 2 different requests for reconsideration, and I want to make sure we do it the right way. So if our counsel, Mr. Warner, is correct, then I'm going to hold off on you until item 9. Is that correct, Ms. Kirkland?
I'm going to go with whatever you instruct me to do. I would like to say, though, I thought I was last in the agenda, so I hadn't put my notes together yet, but so I will, hopefully will be able to express what I need to express succinctly, knowing now that you've moved me to the top of the agenda. But I will go in whatever order that you would like.
I appreciate that.
Online, it does say that item 8 is Ms. Kirkland, and item 9 is Derek Baumgartner, who I think is with the Association of Fairwood.
Yeah, we've been back. I think Commissioner Doyle, there's a bit of a problem. We've been back and forth on this with these 2 items. It goes to the same item. So, Mr. Warner, we get just a hint of clarification on this, or Ms. Proctor? Okay, so Mr. Warner, we have on our agenda that Ms. Kirkland is 8 and Fairwood
I
is 9.
apologize. You're right. I in my packet, they came in a different order and they both say 8, 9. So I thought our first one was Fairview, but you're right. The agenda is as Mr. Dorner said. So I'm sorry, Ms. Kirkland would go first, or you can take 9 first if she needs time to prepare and hear 8 after. Either way. Sorry, thank you.
Ms. Kirkland, thank you, Mr. Warner. And thank you, Commissioner Dorner, for flagging that. Ms. Kirkland, you need a few more minutes. Would that be helpful?
No, what I would request is if
We can't hear you.
Can you hear me now? Can you hear me now?
I can hear you.
I can hear you.
Mr. Chairman, I see your mouth moving, but I cannot hear you.
We can't hear you right now, Mr. Chairman.
You can't hear me?
Oh, now we
you
can.
hear me?
That was
I
scary.
think we do have the holiday ghost in our system, but we'll proceed. I would request, since I thought I was late in the agenda, I see the time from 10 to 5 p.m., that I be able to submit my talking points. I can email them to Ms. Gupta, who is or whoever you would like is the representative that has been the point of contact.
So you can. I want to be respectful and make sure that we're not crowding you, because we have jumped in on the agenda, but there are other folks who are signed up as well. And I just want to make sure that we're not going to there won't be unintended consequences for moving this farther down the road. So commissioners, if you bear with me, Mr. Tabb, are you okay if we push this a little bit farther down the agenda?
Mr. Chairman, yeah, I planned on so the agenda was going to be helpful if it's not too far down the agenda. Sure, that's fine. I certainly want to accommodate the board where we can, but I would suggest that Ms. Kirkland had every opportunity to prepare her notes before the hearing began today, and she needs a few more minutes. That's fine. I just hope it's not pushed too far down. That's all.
Mr. Chairman, I can proceed as long as I can submit my talking points. I will say that I had sent email because I did not know where I was in the agenda, how much time I had. I did not learn of that till yesterday. But I will go ahead and proceed. So first of all, I just want to say—
Before you do, Ms. Kirkland, let me interrupt a sec. Before you do, I just want to read into the record a little bit about what is before us. This is for board members, but for the public at large. Just a reminder. So what's before us is requests for reconsideration of our approval of this preliminary plan of subdivision. So as a reminder, our rules of procedure permit parties of record the opportunity to request that the board reconsider a final decision. Final decisions are generally final, but administrative procedures have long included processes that allow, like we're having here, allow bodies to correct mistakes in limited circumstances to ensure that our decisions are accurate. So under our rules, the right to reconsider a final decision of the board may only be granted if, in furtherance of substantial public interest, the board finds that there was an error in reaching its decision, and that error was caused by fraud, surprise, mistake, inadvertence, or other good cause. So if we do make such a finding, then a hearing would be scheduled at a future date for the board to consider the substantive issue. So what's before us now, the only issue that's before us now is not the substance of the case that was before us before. The issue that's before us was there an error in our decision? And if so, was that error caused by, again, fraud, mistake, surprise, inadvertence, or other good cause? So I'm saying this to say the purpose of this is not to rehear the case in any way, or to provide or to say because there's opposition, we should reopen the case. So Ms. Kirkland, for you and for others, it's very much focused on, did we make some kind of mistake in our process? Not do you disagree with the decision that we made? And respectfully, there's a huge difference between those two things. So I'm going to work with you to sort of keep you focused on that first part and not the second part, not the you disagree with the direction that we went on this, okay?
I appreciate that.
That distinction makes sense? Okay. And that's for both these cases. That's for 8 and 9. We're going to take them up as separate cases, even though they're obviously related to the same preliminary plan subdivision. So with that, if from a process perspective, board members, are there any questions about what we're taking up? Any process questions that you have? Okay.
Mr.
So with
Chairman,
that, yes, Mr. Warner.
Apologize for interrupting again. David Warner, Principal Counsel. Just so that Ms. Kirkland is aware, she mentioned that she wants to submit her written comments for the record, and our rules would not allow for the submission of written comments at this point. The same rule about that being required by noon on Tuesday would apply. So I don't want that to be misunderstood by her. But obviously, she's free to provide her comments verbally.
So am I to understand that my talking points may not be submitted?
Right. The board's rules for virtual hearings requires all written materials to be submitted by noon on Tuesday. Of course, we have your full reconsideration request in writing. That was submitted, and obviously that is before the board. You just can't submit additional written materials after noon on Tuesday. But you can go ahead and obviously provide your comments.
Okay, I will try then, as convoluted as my notes look to me, to make my way through them and hopefully not be redundant or be clear. And I appreciate the chairman's assistance in keeping me in line as he communicated.
Taken away. And I'm going to put 10 minutes on the clock just as a reference for what you said, the amount of time that you think you'll need. That'll help guide.
Thank you. And again, good day to everyone. My name is Tamla Kirkland. My home is located on the street across from the historic Fairview Manor Estate property, also known as 4600 Fairview Vista Drive. Thank you for accepting my request for reconsideration. I submitted a letter setting forth some basis for my request, and this morning I would like to offer several points of further good cause that I believe collectively justify the board in reconsidering the application. I'm going to skip through some of my comments after considering what the chairman has stated, but I do want to make sure that everyone is aware that the subject property is a registered historic property. For more than 200 years, the property was the home of the descendants of Governor Bowie, his descendants, and enslaved people who look like me. And just recently that property changed ownership. Good cause. So one, I believe there is a lack of integrity and transparency, a surprise may be, so to say, that one, and the lawn guy is out cutting the lawn as I speak. So
You're
hopefully
fine.
you hear me
We
clearly.
can't hear it, so you're fine on your side.
Okay, good. So that there was not actually what I believe meaningful notice to the public, and more specifically to the Fairwood community and the adjacent property owners. And I say I don't believe that there was meaningful notice because in 2020 and 2021, the applicant represented to the district council, members of the Fairwood community, and to this planning commission per DSP 2105, still showing in the planning commission system, that the applicant intended to convert the existing structure to a private school for up to 80 students. Please note that the existing structure is a approximate 6,600 square foot house. That is it. That is the only existing structure on the entire parcel, which is the subject property. This is what was represented, again, to the district council, to the community, and to the planning commission until the applicant was able to convince the district council to approve a text amendment. These were meetings with the district council. I want to also note for which the community was not invited, was not notified, and it was not until after that text amendment and recently this year when the applicant submitted its application for a subdivision that we all were shocked to learn of the expansive compound, we'll call it, of a private community center that the applicant calls a school campus, that the applicant now intends to construct. A compound, a community center, which includes approximately 5 new buildings, creating amphitheaters, adding roads, other facilities, parking pads, fencing, all which were not represented in its presentations its DSP application. And so as a result, this is clearly just an outrageous, we believe, bait and switch, and makes a mockery of the county's notice requirement. If the applicant is allowed to move forward with this expansive plan, not only is it surprising, is it, I think, the process unethical in the way it came about, but it forever changes and the character and what was intended per its own indication in the DSP. An issue for consideration for good cause also is that the applicant may not even qualify as an applicant. The only use other than a residence is we are aware that the zoning allows for a school. The Fairwood Community Association, through its attorney, is scheduled this month for a Board of Zoning Appeals hearing to determine whether or not the applicant even meets the private school criteria and legal definition. I urge this board to grant this reconsideration to allow time for the outcome of that Board of Zone Appeals hearing before rendering a decision on the preliminary plan. I believe that is also of good cause. Let's see, going through my notes here. Of significance, and I think further consideration, perhaps an oversight and error, is that the Prince George's County bill that was adopted, I believe it was in November 2021, for the purpose of authorizing the planning board to approve the easements that were needed for the now site plan, the expansive, vastly expansive site plan that the applicant submitted this year, calls for a minimum right-of-way of 22 feet, I believe. It is deemed not adequate. Not only is it deemed not adequate, but I think it's I don't know if her name is Miss Giles or Giles, actually specifically states, and it's in, I think, your staff documents, that entrance roads into the site need to be widened to 26 feet, curb and gutter road, and that is before you even add the sidewalks on both sides. So the applicant's documentation and what has been proposed does not in no way meet the requirements for what has been laid out, what is requirement, and what existing easements allow. I want to note that easements would be required from the existing property owners, the adjacent property owners, the Fairwood Community Association. Those at this time would be rejected, are not approved. And again, the applicant has not showed evidence that it can satisfy the easement requirements of 26 feet wide roads with sidewalks, etc. The traffic study that was paid for by the applicant's consultant, I want to note that there are 3 other developments underway with applications in the Planning Commission system that would bring thousands of new residents, thousands of new vehicles in, out, and through Fairwood. There has been no consideration for that. These are brought about as a result of the recent zoning map amendments. This changes what would be the formula and considerations of traffic studies. I'm going to move. I know I'm running out of time here. I asked for a bit more time. The historical setting of this site is significant, more significant, and it saddens me to see how it seems there is not significance granted to considering what is proposed to be done to this historic site. This is an anchor site in the community. It is of significance to the state, to Bowie. The site is so significant that the entire neighborhood was planned and designed around it as its anchor and center residence. It does not seem there has been any meaningful consideration given to that. The trees that have been proposed to be removed, along with approximately 60 other historic trees on the site, 2 of which have been approved to be removed or recommended for removal, are of such significance that Mr. Duckett, the original builder of Fairview, upon his death in 1810 at Fairview, left the estate to his son-in-law, Captain Duckett Bowie, with the stipulation in his will that if William and his son should have Fairwood, they may have Fairwood as long as they did not cut down certain trees standing near the house. This has followed through the lands for 200 years. Yet there was no consideration given to that. The drip canopies that will be compromised, the root zones critically damaged for at least approximately 20 other historic trees shown on the tree conservation plan in your package. None of that was addressed during the hearing and has not been meaningfully addressed in the staff reports. All of that would be damaged, permanently destroyed as a result of if the applicant is allowed to proceed with the site plan that is a part of this package. I do not find in any of the submissions or the staff reports or by the applicant evidence that for adequate police, fire, safety response, facility, personnel, officers, there is not sufficient evidence to support that this applicant has demonstrated compliance with satisfying those requirements. Collectively, with everything else that has been submitted, I believe that this application was not ready for submission, should have been rejected by the board, and requires reconsideration. Thank you.
Thank you. Sorry about that, Ms. Kirkland. Thank you. Thank you for being mindful of the time as well. Folks, I neglected to give staff the opportunity to present up front. Hold off and let all parties speak, and then we'll allow staff to speak at the end and see if they have any comments about what they've heard.
Mr. Chairman?
Yeah, Mr. Warner.
Point of procedure again. David Warner, Principal Counsel. Ms. Kirkland's public comments, obviously all very valid from her perspective on this project. We do need to note, however, that the scope of her reconsideration request is limited to the items that she identified in her letter requesting reconsideration. That document is required to be submitted to all persons of record prior to this hearing, and it also gets evaluated then by staff. So she brought up a couple issues that were not in her original request for reconsideration, and we can't consider those now at this time when she brings them up for the first time.
Mr. Chairman, may I respond?
That would, yes, ma'am.
Mr. Chairman, may I respond?
Yes, ma'am.
Mr. Chairman, may I respond? 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 Mr. If I
Let me just
may,
finish. If I
Ms.
could just
Kirkland.
finish.
Ms. Kirkland, let me let Mr. Warner finish, and then I'll give you a chance to respond.
Right. So as I noted in her presentation, she covered a lot of items that were in her letter, but she brought up for the first time what appears to me questioning the analysis of the tree removal, fire and police response. And at the beginning of her presentation, she did refer to a lack of notice. And if she's referring to lack of notice for the preliminary plan application, that was not something she brought up in her letter either. She did talk about lack of notice of the zoning case at the county council or the district council level. But so we just need to be careful when analyzing this reconsideration request that we limit that analysis to the items that she put forth in her letter and not new items that she brought up for the first time at this point in the process. Thank you.
Thank you, Mr. Warner. Ms. Kirkland, reactions to that?
I am giving testimony. It is my understanding I do not have to limit my testimony to the exact words typed in my summary overview request. Everything that I have stated is related to and correlates to what is in my letter, what I received as submissions that others have submitted. It all is around the historic nature of the property, safety, the surprise and shock that was put upon the community, a community which I think for the record, you also have a copy of petitions signed by more than 500 homeowners in the community during the past few months, also surprised and shocked by this bait and switch change of what was initially represented by the applicant and then changed when it submitted its application. And I refer to notice being the community notices, the adjacent property owner notices. It's my understanding that written notices, I believe at least 2, were to have been sent to the adjacent property owners and the community members. I live across, my street is across from this property. I never received any written notices. I learned of this property through a bulletin notice buried in a Fairwood Community newsletter, and when I saw a sign posted at the property 30 days prior to the planning board's hearing. That's what I learned. Everything I said and my testimony is valid and related to what is in my request for reconsideration.
Okay, thank you, Ms. Kirkland. So again, I'm going to ask staff to go after we've heard from, if there's additional folks who are in support of the reconsideration and folks who are opposed to this as well. So Ms. Gupta, if you could be prepared to address any issues that you hear as you go along. So Ms. Oliver, you also are requesting reconsideration. Is there anyone else on the line who wishes to speak in support of the request for the reconsideration in addition to Ms. Oliver? I have another person listed on my sheet, but I don't know if that's anybody. I don't know if that's another.
May I ask a question? The petition for reconsideration was filed by Ms. Kirkland. She spoke to every issue on that. I'm not aware that anyone else has an ability to come in and simply speak to the issue she already spoke to. This is a petition for reconsideration, and you correctly stated the criteria for that. And I question whether or not others have the ability to go ahead and speak to that when she has already put in exactly what she believed to be the basis for her petition. And that's where we stand. That's the basis upon which the board must make a decision. I'm not sure. This is not a public hearing, as did occur 2 months ago.
Right, I'm with you.
But your process also allows for speakers to sign up and be heard. Sign up.
I just want to get clarification from council. Mr. Warner, my understanding is if folks have signed up to speak in support of this reconsideration, they are eligible. Am I misunderstanding that?
Yeah, that is correct. The board's procedures allow the board to take public comment on requests for reconsideration. And so if you, we've allowed Ms. Oliver and anyone else to sign up the right to speak. And so it would be appropriate to allow them to speak. It is a hearing pursuant to the board's procedures. It's not an evidentiary quasi-judicial hearing, but it is a hearing. So we accept public comment on the item from those that sign up to speak.
Thank you, Mr. Warner. So, Mr. Taub, I hope that addresses it from our perspective. The only folks who can speak are folks who signed up by noon on Tuesday. So is there anyone else besides Ms. Oliver who has signed up who is here to speak? And Mr. Taub, I'm not referring to you.
I understand, but I also want to be sure anybody else signed up to speak was a party of record to this case as well.
I'm assuming Ms. Oliver signed up to speak and she's a party of record.
Yes, both.
Okay. Okay, Ms. Oliver, I'll turn to you. How much time do you need?
I would say 5 minutes, and I would like to allow request that Ms. Kirkland continue using my time to speak to complete her presentation.
We're not structured in that way. I appreciate that. It's kind of you. We're not structured in that way. If Ms. Kirkland had asked for a few more minutes, I certainly would have granted that. But the time is yours, and so take the time you need to present. And I hear you saying that you're going to need about 5 minutes. So I'm flexible around that, but I'll put that on the clock. And as we approach that, if you need a little bit more, I'll certainly grant that.
Okay, thank you. I really will not need much time. I am here in support. I am also a homeowner and the vice president of the Fairwood Community Association, the board, and I am here in support of this reconsideration petition. I agree with Ms. Kirkland's points as it relates to surprise error that was made with the decisions to move forward with the decision to move forward with this development in light of the fact that the notice that was, or the intention that was represented in the application and notice that was given to the community really related specifically to the development of the Fairview Vista Manor historical home, not the building of an entire compound, which would impact the community. I also agree with the point as it relates to the easement and the fact that even in your record, the easement issue as it relates to the requirement of 26 feet has not been addressed, yet this development has been allowed to move forward. I also agree with the fact that the traffic study did not take into account the many pipelines of developments that would impact the community. And finally, from a process standpoint, I don't understand, and I think this is an error as well. I know it's an error. Why the Planning Commission would move forward with a development application where the actual applicant is legitimately not considered a school under the laws of the county, neither the state. That issue is being addressed and will be addressed in a hearing, which we filed a petition regarding that with the zoning appeals, and it would make more sense to wait to see what the resolution of that case is before moving forward with this development application. And so with that, that concludes, and one other item, which is the trees. Again, and I actually read that resolution myself, where it was where the Bowie estate was transferred and specifically stated that those trees should not be removed. And that's been in place and has been a covenant that has run with the property for over 200 years and was not addressed at all in the documentation. And it really is improper to remove those trees. And that concludes my comments. Thank you.
Thank you, Ms. Oliver. Appreciate it. Commissioners, I can turn to questions, but again, I think having missed the opportunity to hear from staff, I think what makes the most sense is to hear from Mr. Taub, then hear from staff, and then we can open it up. We'll have a sort of a clearer picture, and then we can open up for questions. But I'm open if you have questions right here, right now for Ms. Kirkland and Ms. Oliver, I'm okay with that as well. What do you want to do? You want to wait? Or you want to ask now?
Well, Mr. Chairman, I don't have to articulate this in the context of a question, but I would like to put 3 issues forward. So as staff prepares and Mr. Taub prepares, clearly a lot of passionate testimony and comments, but the only thing I heard that may get close to error, which again is the criteria through which we have to make a decision, has to do with this easement issue and 26 feet not being achieved, the applicant not being considered a school, and then the covenant issue with regards to the trees. So I just wanted to put those out there for staff and others to consider in their comments. Thank you, Mr. Chairman.
Thank you for that. Mr. Joyner, anything on your side before we turn to Mr. Taub and then staff?
No, sir.
Okay, thank you. Mr. Taub, take it away. How much time do you think you'll need?
Mr. Chairman, I'd say if you can give me about, let's say 7 minutes, see where we go from there. That should be fine, maybe less than that. Actually, 7 minutes is fine. First of all, I want to say that with regard to the specific petition
You
by...
just have to identify yourself for the record and who you represent.
Sorry, my apologies. For the record, I'm Larry Taub, attorney with the law firm of O'Malley, Miles, Nowlin, and Gilmore, here today representing Chance Academy, the applicant for this in this matter. First, I want to say that this matter, of course, is a preliminary plan of subdivision. It is not a detailed site plan that would be coming before the board as the next step in this process. Important because I think that in that context, it must be understood that, and I'm going to go by the Ms. Kirkland's petition, and I'm going to go through each one of her points here. There'll be points 1 through 7 are all irrelevant to the subdivision. Point 8 is with regard to the traffic study, which was prepared under the guidelines of the commission, was evaluated under the guidelines and found to be acceptable. Number 9 has the, with regard to the traffic issues are irrelevant. Those are DPI issues. The stormwater management concept plan is approved by DPI. And with regard to they simply disagree with the Historic Preservation Commission. That's nothing more than disagreement. And items 12, 13, 14 are also irrelevant, again, to the preliminary.
Mr. Taub, you're on mute. You muted yourself.
All right, my apologies. So I'll repeat that 12, 13, and 14 are also irrelevant. I want to say here that with regard to the petition, this is not a second bite of the apple. Every single one of the points made by Ms. Kirkland and Ms. Oliver were issues that could have been raised at the initial hearing on this matter. This is not allowing one to come back in and simply say, we disagree, we want another opportunity to make our points. As the chair pointed out originally, the criteria for petition for reconsideration or it has to be fraud, surprise, mistake, inadvertence, or other good cause. I don't believe that any of that has been proven here, has been shown here, has been in any way displayed in a manner that allows the board to go ahead and reconsider this matter. The staff did an excellent job of evaluating the application in all respects, as it always does. and the case was well argued. The citizens had every opportunity to speak at that hearing and did so, as did Mr. Baumgartner with regard to his representation of the community association. There is simply no basis here for a reconsideration. As I said, there's just there's nothing here that was stated. With regard to the tree issue, I would indicate that was not an issue, as Mr. Warner pointed out, that was raised in the petition for reconsideration. It's not an issue that can be raised here today. That was not, there's a time limitation in which the petition for reconsideration can be filed. All the issues must be raised in that petition. That was not an issue that was raised at that point in time. With regard to the easement and Ms. Washington's concern, I would say that's an issue that needs to be dealt with at the detailed site plan. Again, this is simply the preliminary plan of subdivision, and that is not an issue at this point in time that need to be dealt with. That has to do with site development. And the issue also of not being a school, that's an issue that could have been raised at the hearing, but was not. And also could be raised at the hearing before the board at the detailed site plan stage. But right now, the preliminary plan of subdivision was for an institutional use, was not necessarily even for a school. So I would suggest to you, although there were criteria, the traffic study was based upon the proposal that was before the board. That's correct. But by and large, there is no basis here for reconsideration in any way. The citizens have not proven that the fraud, surprise, mistake, inadvertence, or other cause. And I would respectfully suggest and that there is no basis and respectfully request that the board deny the petition for reconsideration. Thank you very much. I'd be happy to answer any questions.
Thank you, Mr. Taub. Board members, questions for Mr. Taub? No questions. I'm going to turn to staff.
Mr. Chairman, this is Tamla. May I ask a question of process by you?
Of our process? Yes, of course.
Yes, so I want to, because I'm not an attorney, I'm not a subject matter expert. This is my first time with the reconsideration hearing. I want to understand, particularly for our community. So we participated in the hearing. We brought up the issues that some of which Mr. Taub said were not brought up, but they were brought up either through written submission or through testimony. And so, and we reference staff reports. So my understanding is that the reconsideration addresses errors, oversights, surprises, et cetera, that were found, that we believe were found and justified. And then so my understanding is this is the purpose of this reconsideration hearing, is to address those things. My other point is, and I don't know if I can, Ms. Washington, I mean, I have found her adversarial to the community and so pro this project for so long that I want to make note.
Kirkland, I'm going to stop you there because this is not the opportunity for an ad hominem attack on a board member.
Well, I'm sorry. I respectfully don't mean to attack Ms. Washington. I just want to understand, are the commissioners, are they in any way, can they be affiliated with a project, or do they have to be neutral? Do you represent the interest of the developer, the community, what is the role?
No, this is not germane to, I mean, you may have concerns about the integrity of me, my fellow board members, and that is certainly your right as a resident of the county, but that's not germane to this case before us, to this reconsideration before us. So I'm going to stop you on that.
Thank you.
Thank you. So let me turn to staff and see. Ms. Oliver, you have a question?
Yeah, just a question. So can staff address those issues that Mr. Taub raised, that stating that these issues were not raised in the hearing, neither in our written testimony? Because I know they were raised, because some of them I raised myself in hearings and in my written testimony. So I know that statement is absolutely not true. And I'd like staff to address that.
Thank you, Ms. Oliver, and that is my intention to have staff address that. I would say what I heard Mr. Taub say is not that these issues were not brought up by people. What I heard more was that issues that were germane to the preliminary plan of subdivision were brought up. And there were a number of issues that will be taken up at detailed site plan that are not germane to this conversation. That's what I heard. So I did not interpret him to say, I don't want, it's not like you're crazy. You said some things at the hearing that you said, and we were there and we heard it. And Mr. Taub did too. So that's my interpretation, Ms. Oliver, for what it's worth. So Mr. Hunt, Ms. Gupta, you want to run through, and I think the specifics, Mr. Taub did a version of this, but you may have your own version of this when I look through the staff report of the items that were brought up in the reconsideration request, which ones are germane, which ones weren't taken up. I will leave it to you, but you had a fairly thorough staff report. If you could summarize that. I do not think we need to go through all the ins and outs of the project that are in the PowerPoint. And I would say if you can get to the specific issues that are relevant to us for this reconsideration.
Yeah, thank you, Mr. Chair. And doing a sound check. Can you hear me?
Yes.
Okay. Yeah. Good morning, Mr. Chair and members of the board. For the record, I am Mridula Gupta with the subdivision section. So I'll skip my regular script for this and I'll go directly that in her request, Ms. Kirkland states 14 reasons why the planning board should reconsider their original decision. In staff's opinion, the reconsideration request, however, does not state or provide specific evidence that there was an error in reaching the final decision. I'll turn my volume up. I'm sorry.
We can hear you okay.
Okay. Numerous points were raised in the request, which were, in staff's opinion, either previously discussed during the planning board hearing on the case on July 7th, 2022, or are not under the purview of the planning board, or are not germane to the review and consideration of the preliminary plan of subdivision application. And as you did state that staff did provide comments on these specific points, and I can go through the items number.
Go through the items because we have 1 through 14, right?
Yes.
So just go through those on the report, either the report, I don't know if you have it in the PowerPoint. I don't think you do, but you do have it in your report.
Yes, so it's listed in the staff memo that is provided, that was published and provided to you on the 3rd page. I'll be basically reading out from that.
Take it away.
Yes. So items item 1 of the reconsideration request, it referenced an appeal submitted to the Prince George's County Board of Zoning Appeals on behalf of the Fairwood Community Association. Items 2 and 3 asserted that the proposed use on the property do not meet the criteria of a private school. Items 8 and 9 discuss the traffic impact study and Ms. Kirkland's general opinion of the traffic within the neighborhood. And item 11 discusses the historic site in general. So staff believes that all these points, items 1, 2, 3, 8, 9, and 11, were discussed during the July 7th, 2022 planning board hearing and were considered in the decision-making process. And this was summarized in a new finding 18 that staff added to the planning board resolution.
I think what's going to be the most helpful for our edification as well as for the record, if I'm looking at the staff report, right at the beginning of the staff report, you've literally listed out each item. And if you could just go through that.
That's actually letter.
Okay.
I'm sorry, are you looking at the backup?
Mr. Berlage is here too, and he's making a suggestion about what he thinks is going to be most helpful for this as well. So I'm looking at I'm actually have it, is this the backup?
Yes.
It is in the backup. Chair, suggest to her what it is that we're talking about. I just want to make sure we're getting this right for the record. So Ms. Gupta, hold on one sec.
Thank you very much. Ms. Gupta, in the staff backup, is the actual request for reconsideration from Ms. Kirkland.
Yes.
It's the letter dated August 5, 2022, and it lists the 14 items. If you could go through each of those 14 items and briefly explain why what staff's response is to each item, that would be, I think, the most helpful to the board.
Pardon me, Mr. Chairman, you
Yeah.
also have the reconsideration submission from the Fairwood Association attorney that was submitted in time, that also, I'm guessing, is being considered at the same time?
That's the other case. So as odd as it is, since they're both related to the same preliminary plan of subdivision, we'll be taking that up after we conclude this case.
Thank you.
Mr. Chairman, this is David Warner again. Real quickly.
Yeah, yes, sir.
While it's fine for staff to go through each of the 14 items on this list that Ms. Kirkland submitted, we have to remember that it's not a question of whether it's not a reevaluation of the findings in the preliminary plan. As you said at the beginning of this entire matter, that decision is final. The only issue is whether there was an error in the board's decision. Now, the request for reconsideration that Ms. Kirkland submitted did not expressly say that there was any error made. They were all challenges to findings made in the preliminary plan hearing. So to the extent staff is going to address each of these 14 items, that's fine, but they should limit it to explaining why there was no error and not reevaluate their findings and have a dialogue about that. Is that, I think that might clarify a little bit about what we're looking to do here.
And one issue, though, one way there might be an error is if we did not take up an item that was of critical importance to the process. So by staff addressing that, if staff addresses that an issue was taken up by the board, was considered, for me, that's okay. Then we follow our process.
I agree with that. Yep. Thank you.
All right.
Mr. Chairman, my written submission is a general overview, which is supported, my understanding, which would be supported by my testimony giving at hearing. It is not my understanding through procedure that only of consideration would be specifically the exact words stated in the summary of my reconsideration. That is why we have testimony. I gave general points to be supported and by testimony by myself, testimony by others. So I take exception that there are members in attendance today who want to limit and constrict the interpretation of the reconsideration only to the exact words typed in the letter. We have testimony.
Ms. Kirkland, our process is our process, and I appreciate your concerns around that. And I want to be clear about something, which is we're going to continue to consider this. I lost my words. Reconsideration. Regardless of how this goes, you have rights through this process, right? So there will be. If things move forward, there will be detailed site plan. You will have another bite at that apple. If you truly believe that we have erred, you can take this to the courts. There are a number of things that you can do. What I'm working with my team to do is to make sure that we are being very strict about what is before us with this reconsideration. And a reconsideration is a relatively narrow process. Forget about all the jargon. A reconsideration means we screwed up somehow. We didn't make a decision that you disagree with, but we didn't follow our process in some way, shape, or form to the point where you are saying we need to reconsider, we need to take this preliminary plan of subdivision back up because we screwed up in our process. That's essentially what's before us. Now, I commend you for going at it and pushing through, because I hear loud and clear that you have some real concerns about this project. And I'm giving you a lot of latitude around this. I really am. And I just want to be crystal clear, though. It's a high, high bar to have us say that we believe that we have screwed up in such a way that we need to take this issue back up. We've screwed up in our process in such a way. But that is the process that's before us. And so we're gonna go through this. But our team, our planning department folks and our attorney are going to be very strict, and I'm going to listen to them about what is germane to this process, what's before us. It may not feel fair to you, but there are other bites at this apple. This one is a high bar.
Thank you, Mr. Chairman. I appreciate that, and I will have confidence that the panel will consider that you won't ignore what you've learned today or what you've learned through this process just because there's a T. I know you have to cross your T's and dot your I's, but you can't unhear what you've heard in testimony of learned today. Thank you.
Thank you. Okay, so Ms. Gupta, if you can run through succinctly the items and just let us know what staff's position is on whether or not it merits reconsideration based on those issues.
Thank you, Mr. Chair. I'll try to be short and succinct.
Thank you, Ms. Gupta.
So as I said, item 1 on Ms. Kirkland's letter informed that there is a zoning appeal that's under consideration, and that was presented to the board. That was discussed during July 7th meeting. Items 2 and 3, they claim that the proposed use does not meet the criteria for a private school. These 2 items were also discussed on the July 7th meeting. Item 4.
Ms. Gupta, they were discussed, but also this is something that will come up at the detailed site plan, right?
Yeah, so the use, as I reiterated, if I recall during that meeting, that subdivision does not approve a use for the property. We evaluate a proposal based on what's presented to us, and that's not the final development proposal in front of the board, or that'll be reviewed by staff.
Okay, thank you.
Yes.
Thank you for that clarification.
Mm-hmm. Comment number 4 also pertains 4 and 5. They also pertain to the perceived use of the property for private school with institutional buildings, which essentially are not germane to the review and consideration of the preliminary plan application. Number 6, also it talks about how the Fairwood community is not is against this development. That's also not germane to the review of the preliminary plan. Number 7 discusses the easements that may be required by the applicant, and it claims that these easements shall not be granted. It's that this point also will be determined at the time of site plan, when the details are fleshed out, and if the applicant needs a further easement. That is not an adequacy issue that was evaluated with the preliminary plan. Items 8 and 9 discussed transportation and hazards and pedestrian hazards. They were also discussed during the July 7th meeting, and they were considered by the board in making the decision. Item 10 was also essentially it claims that the stormwater management proposed is inadequate for the site. So these, this stormwater management is addressed in a finding in the staff report and also in the adopted resolution. So stormwater management was discussed in finding 9 of the resolution, and easements that are mentioned in item 7 was discussed in finding 7 of the staff's resolution. Items 11, it's essentially that discussed the historic nature of the property that was discussed during the planning board hearing. The 12, 13, and 14 discuss paying of property assessments, engagement with the neighborhood community, attempts by the community to purchase the property. These 3 items, number 12, 13, and 14, are not germane to the review and consideration of the preliminary plan of subdivision.
Thank you. Thank you for that thorough review.
I can add some information about the mailings that were done by the applicant, and this is based on what the applicant submitted to staff. Informational mailing. This is the mailing that's done by the applicant before they submit, before a case is accepted by the staff. The informational mailing was dated October 28th, 2021. And the acceptance mailing was done by the applicant on March 10th, 2022. And again, this is based on information provided to us by the applicant. There was discussion about the 2 trees that were approved for removal. These are 13-inch diameter American hollies. And staff would note that any additional trees that may be impacted will be reviewed and evaluated at the time of subsequent applications, which will include site plans and type 2 tree conservation plans. Regarding the private covenant that was mentioned, and Commissioner Washington was also concerned about that. So staff's review for historic trees and specimen trees is based on the code requirements listed in subtitle 25 and subtitle 24. I'm not sure we look at private covenants that are between 2 individual parties. Commissioner Washington also referenced the easement issues, though that also will be addressed at the time of the site plan. And Commissioner Washington also referenced applicant not considered the applicant's request that's not considered a private school. That also is not germane to the review of a preliminary plan. That also will be determined at the time of DSP. As Ms. Kirkland mentioned, that has been submitted by the applicant, but it's not been accepted yet. I hope I have answered all the questions from my notes.
I thought you were very thorough, Ms. Gupta. I appreciate it. Commissioner Dorner, Commissioner Washington, any questions for staff?
No, I think I'm ready for a motion and a vote.
Okay, I have no questions either. I appreciate everybody's time on this. Again, the process is the process, and I appreciate that their community folks feel enough passion around this to take the time to go through a reconsideration request. We have our process. Again, there are a number of bites of the apple. It is very important that we stick to our process to this because the applicant has rights too. So given that, Staff, anything else from staff? Mr. Warner, anything else for you before we consider action?
No, nothing additional to add.
Okay. So what is your pleasure, commissioners?
Mr. Chairman, I associate myself strongly with your comments and thank you for your leadership throughout this discussion. And with that, I move that we deny the request, the Kirkland request for reconsideration of preliminary plan 4-21047.
Second.
We have a motion and a second. This is item 8. We'll be taking up item 9 in a bit, even though it may feel familiar. So item 8, there's a motion and a second to deny the request for reconsideration. If there's no further discussion, I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
I'll go ahead and, so I'll vote, but before I vote, I'll add for just discussion purposes, that I hear what the applicants were saying, or I guess not in the sense of the applicant from the property owner, but the community. And I appreciate them pursuing this hearing. I went back and I watched, since I wasn't in the original case, I went back and I watched like 2.5 hours of the original case, and it was thorough. And it's obvious that there's some disagreements about like how some things are viewed and how they're weighed, and what's the quote unquote right or wrong decision on stuff. And that's fine. That everyone is entitled to not necessarily support or feel the same way on issues. It just happens, and that's what happens when we have diverse communities. I think, and I'm not an attorney, but I think the request for reconsideration is more aptly or would be more appropriately done as an appeal if they wanted to actually appeal this, or just to stay engaged and talk to Mr. Taub and the applicant that's actually going through this development and remain engaged in the process. To me, when I'm hearing what I've heard today and what I heard at the hearing before, I don't see any kind of error that was made in the decision. Whether or not they think it was the right decision is I believe, a different thing. The errors usually are coming about because we didn't know that there was another major intersection that wasn't considered in a traffic study, or we didn't know about a major issue that hadn't been taken up that would have affected the decision. If there was no real impact from something that was omitted or just was misconstrued or that came up, there's really no error in the decision itself. And for that reason, I would vote in support of the motion and deny the request for reconsideration. Not necessarily saying that the citizens are wrong or Mr. Taub was wrong in the assertions, or even that the planning board was wrong in its decision, but just simply that I don't think there was an error in the decision-making process that happened in here. I haven't heard evidence of that today, at least. And that I just want to put that under the discussion, just because I didn't hear anything from the testimony today that would make me feel like we have to actually bring this case back before us.
Thank you for that, Commissioner Dorner. I vote aye as well, and I will also, in explanation of my vote, I'll associate my remarks with Commissioner Dorner's, and I think that was a thoughtful articulation of what
Chair,
for us we make the decision that we do.
I'm not sure Mr. Dorner actually voted. Did he? Did you vote?
He did.
Mr. Dorner?
At the tail end, he voted yes.
I didn't hear that. Okay, sorry.
So, and I vote yes as well with my explanation. And so the vote's 3-0 to deny the request for reconsideration hearing for preliminary plan subdivision 4-21047 Chance Academy. Thank you all. So this was item 8. And now we're going to go to item 9, which is, surprise, surprise, a request of reconsideration hearing for a preliminary plan of subdivision 4-21047 Chance Academy. I understand that Mr. Baumgartner, who was the attorney for some of the opponents, would like to speak, but he did not sign up to speak in time for the deadline. We're strict about that, Mr. Baumgartner and others. So no disrespect to anybody and who represents who. If you don't sign up by noon on the Tuesday before the hearing, then you're not offered the opportunity to speak. We're just crystal clear about that. That's why Mr. Baumgartner won't be speaking. We do have.
Mr. Chairman, this is Derek Baumgartner. May I be heard on a very brief point of order?
Baumgartner, no. I just explained why you are not eligible to speak. So, Mr. Warner, do you have anything else to add on this matter?
No, I do not.
Okay. All right. So we do have.
I'm sorry. Mr. Chairman, this is Ms. Kirkland. I am signed up to speak, and I request that the submission by the attorney be read.
I'm going to deny that out of hand. So what we have folks who've signed up to speak for this case, okay? I have one speaker. I'm going to allow a little bit of latitude on this just because there's been some confusion about who signed up to speak in what case. On my list, I have a Colette Harris who signed up to speak for this case. Do we have a Ms. Harris here? I also have Ms. Oliver. You have signed up for this case as well. That is the only other person I have who signed up for this case. Ms. Gupta?
Mr. Chair, Ms. Harris emailed me earlier this morning that she will be unable to attend or speak at today's planning board hearing.
Okay, I don't want to sound too arbitrary about this because we're not being arbitrary. Our process is our process. We are crystal clear that if you want to speak at a hearing, that you sign up at noon on the Tuesday before the hearing. So the only person we have signed up to speak for this case is Ms. Oliver. Is there anyone on the line who feels like they did sign up by Tuesday and we somehow neglected to note that? Okay, so Ms. Oliver, the floor is yours. How much time do you think you'll need? And again, I don't want to sound silly about this, right? Because obviously we're all in this room. We all just went through what we went through in the previous case. It is not the same case because it is separate request for reconsideration. It is a separate request for reconsideration. But again, you have the floor because you have the right to speak.
Yeah, what I would ask for us to do is deliberate and respond to the points that were noted in the petition. Have staff respond to it, and then from there, I will have, if I have any comments, I will make them at that point. I would prefer to have that order. Thank you.
Oliver, that's thoughtful, and I appreciate that. So let me turn to staff on this separate petition, this separate request for reconsideration. And I actually didn't look at my notes on this one separately. So do you have a separate report on this, Ms. Gupta?
Yes, Yes, Mr. Chair.
Okay, so let's pull that up, and I'll turn it to you for a staff report.
Yeah, good afternoon, Mr. Chair and members of the board. For the record, again, I'm Mridula Gupta with the subdivision section. Item number 9 on the agenda is another reconsideration request for preliminary plan of subdivision 4-21047, Chance Academy. This preliminary plan was approved by the board on July 7, 2022, and the resolution was adopted on July 28, 2022. By letter dated August 9, 2022, Mr. Derek Baumgartner, representing the Fairwood Community Association, or Fairwood, requested a reconsideration of the Prince George's County Planning Board's approval of this preliminary plan. Fairwood requests reconsideration of the Planning Board's approval of the preliminary plan of subdivision with their claim that the board failed to make a proper finding of adequate public facilities in compliance with Section 24-122.01 of the prior Prince George's County subdivision regulations. Fairwood states that credible evidence, reference documents, and correspondence were not provided in the backup of the technical staff report, and therefore the resolution did not adequately address police and fire and rescue facilities for the subdivision. Fairwood claims that mistake and inadvertence associated with reaching the original decision is good cause for the requested reconsideration. Staff's analysis of the preliminary plan of subdivision and its findings for this application were conducted in accordance with standard established practices and use of well-documented resources that are used for all preliminary plan of subdivision applications. It is not customary that reference plans and all sources of data, guidelines, and/or regulations are included in the backup for each application. Staff notes that Fairwood, in their request for reconsideration, do not put forth evidence that any error has been made in Planning Board's determination regarding these public facilities. If the Planning Board grants the applicant's request for a reconsideration, staff will provide an analysis on the merits of the request at a later Planning Board hearing. This concludes staff's presentation. Thank you.
You're on
You're on
mute.
hearing, Mr. Chair.
My turn. Ms. Oliver, I'll turn to you if there's any, you have the floor, if you have anything that you want to add or share related to what you've heard from Ms. Gupta. You did sign up to speak and you have the right to speak, so the floor is yours.
I appreciate that. I'm not going to be long or belabor the points that were made in the petition. I support that petition, and I do believe as a point of process that development should not move forward when these types of outstanding issues are present. The adequacy of the public facilities is significant enough that this development should not be moving forward to the next phase without addressing those issues. And that concludes my comments. Thank you.
Thank you, Ms. Oliver. Appreciate it. Mr. Taub, anything you want to throw in?
Thank you, Mr. Chairman. I appreciate that very much. Again, for the record, Larry Taub, attorney with O'Malley, Miles, Nowlin, and Gilmore, with offices in Greenbelt. Simply to say here that as I discussed in the prior case, this is a petition for reconsideration. The issues raised by Mr. Baumgartner in his petition were those that were certainly available to be raised at the hearing on this matter 2 months ago. There's nothing that he raised that is in any way could be considered fraud, surprise, mistake, inadvertence, or other good cause. Again, as with the prior application, in many cases, simply a disagreement with the decision of the board and his disagreement with the evaluation. Well, again, those are issues that could have been raised by him at that hearing. He was given ample time to testify. That could have been raised. It was not. And I would respectfully suggest that this is not a sufficient ground for reconsideration and under the procedures of the Planning Commission. And I respectfully request that you deny the petition. I'd be happy to answer any questions.
Thank you, Ms. Taub. So I turn to my fellow board members. Any questions for staff or Ms. Oliver or Mr. Taub? If none, then I'll look for a motion.
Mr. Chairman, I move that we deny the request for consideration for preliminary plan 4-21047. And thank you, Ms. Oliver, for your comments.
A second.
We have motion to second to deny the request for a reconsideration. If there's no further discussion, I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
I'll vote aye. Just for discussion purposes, I'll just kind of reiterate, similar to the last case. I haven't heard anything that would say that there was an error that was made. So regardless if we didn't have certain documents in the backup that were maybe desired by other parties, there was no allegation that made an error or some sort of a mistake in the decision that was made. And I think staff adequately mentioned that sometimes we don't have everything. We have long packets. We get 200 to 300 pages on some of these cases. And that's just a snapshot of what all the folks are doing in the scenes and kind of doing and trying to summarize it all so we can go back through every week and read through all these cases and the backup materials as well. Sometimes stuff isn't included because it's not considered germane to the ultimate decision, and we get sort of summarized information about it. All of that can be brought out at the case itself and questioned about like the validity of it, whether or not we think it's adequate or we think more is needed. And since there's no statement saying that we didn't have enough information or not that there wasn't enough information, that we made the incorrect decision or some sort of mistake because of the lack of information or something like that, I don't think we need to reconsider this case. Again, I think that would be something on appeal that could be raised, or maybe even in later stages of these cases as it continues to go forward, if it does, that the citizens who are obviously engaged at this point and have an attorney there can continue to make sure that they dig a little bit further and have offline conversations with Mr. Taub so that way there's better understanding of everything that's going on with any potential future projects. And again, I'll vote in favor of the motion.
Thank you. Thank you for the explanation. And I vote aye as well. The ayes have it 3-0 to deny the request for reconsideration hearing for preliminary plan subdivision 4-21047 Chance Academy. Thank you, everybody, for your participation on this case. Next item on the agenda. Commissioners, do you need a quick break, bio break? Are we okay to keep going? Okay. Yes. All right. So let's take a 10-minute break. Let's reconvene. It's 12:19 now. Let's reconvene at 12:30.
Mr. Chair, if I may ask a question real quick. Our Nate Foreman, for the record, I'm the attorney for the applicant in item number 5. Unfortunately, our architect, who is part of this case, actually has to leave for another meeting at 12:30. So I know I don't know if this would we even went forward with the case now, he'd have a chance to be here for answering questions, but at least there'd be a possibility for that.
Commissioner Washington, can we hang on 10 minutes?
Absolutely. I was just going to say that's fine.
Okay.
All right. So let's take up. No, thank you. Let's take up this case now. So what's before us is item 5 on the agenda, STP 8804-02, Carlington Center, Nassau Federal Credit Union. For the staff, we have Mr. Butler and Mr. Foreman, who has spoken to the attorney for this. Let me turn to staff for a brief presentation on this item.
Good morning, Chairman and members of the Planning Board. For the record, I am Tiara Butler with the Urban Design Section. The project before you is item number 5, Specific Design Plan STP-8804-02, Carlington Center, Nassau Federal Credit Union, which is a specific design plan for the construction of 2 4-story buildings with associated improvements. Next slide, please. This site is located in Prince George's County Planning Area 74A in Council District 4, as shown in the green color on the map. Next slide, please. The site is located on the eastern side of Prince George's Boulevard, approximately 400 feet north of its intersection with Trade Zone Avenue. The site boundary is shown on the vicinity map outlined in red. Next slide, please. The subject property is Zone Legacy Comprehensive Design Zone, LCD, under the current zoning ordinance, as shown in red on the zoning map located on the left side of the screen. The property is Zone Employment and Institutional Area, EIA zone, under the prior zoning ordinance, shown in red on the left side of the screen. Next slide, please. This slide shows the property is not located within any overlay zone. Next slide, please. This slide shows the aerial photo, which shows the existing conditions of the property, which shows the vacant lot 9 and the existing 54,090 square foot office building and parking located on lot 8. Next slide, please. This site contains slopes, which is shown with the red contour lines on the map. Next slide, please. This slide shows the master plan right-of-way. The site is located near U.S. Route 301, which is classified as an arterial freeway, as shown in the red and orange color on the map. Next slide, please. This slide shows the bird's eye view of the property, which shows the existing office building on lot 8, as outlined in blue, and then the vacant lot 9. Next slide, please. This slide shows a site plan. The application proposes to construct 2 4-story office buildings and associated site improvements located in the middle of proposed Lot 9. Each of the proposed buildings will be 4 stories tall and will be 42,284 square feet. The proposed office building will be connected via a 5,462 square foot connection. There will be parking lots on the east and west of the building that will be accessed via 2 driveways from Prince George's Boulevard and 2 driveway connections to the adjacent Lot 8. The adjacent Lot 8 contains a 54,090 square foot office building and parking that are to remain, and Lots 8 and 9 will contain a total of 590 parking spaces, 2 bike racks, and 4 loading spaces in the rear of the building. The site will contain multiple bioretention ponds with 2 along Prince George's Boulevard and 4 along the rear of US 301. The site will have 2 dumpsters, 2 concrete transformer pads, and then 2 generators located in the rear eastern parking lot area. Next slide, please. This slide shows the landscape plan. The required plantings and schedules provided on the plan are in conformance with the landscape manual, except for section 4.4. A condition has been added to provide a schedule that demonstrates conformance with the section 4.4 requirements. Next slide, please. This slide shows a type 2 tree conservation plan. Next slide, please. This slide shows the architectural elevations for the east and south elevations. The 2 proposed buildings will be 42,284 square feet each and 59.5 feet tall for a total of 4 stories. The front elevations will be oriented west towards the Prince George's Boulevard. The buildings will be rectangular shaped with flat roofs. The finished materials and of the building will include metal panel and brick. The building will be a combination of light and dark gray with windows and metal canopies above the entrances. Building mounted signage is being proposed to include a channel letter sign with a logo, which is typical for office building and found acceptable, and a condition has been included to require the applicant to provide scaled details of the sign in accordance with our applicable sign regulations. Next slide, please. This slide shows the architectural elevations for the proposed west and north elevations. The west and north elevations will consist of similar building materials as the east and south elevations shown on the previous slide. Next slide, please. This slide shows architectural elevations for the proposed courtyard. These elevations will consist of similar building materials as the other sides of the building. Next slide, please. And with that, urban design staff recommends that planning board adopt the findings of this report and approve specific design plan SDP-8804-02 and type 2 tree conservation plan TCP2-013-08-01 for Collinton Center, NASA Federal Credit Union, subject to the following conditions found on page 14 and 15 of the staff report. And this concludes staff's presentation.
Thank you, Ms. Butler. I think I said Mr. Butler. I apologize earlier.
Oh, no, you're fine.
Thank you, Ms. Butler. Questions for staff before I turn to Mr. Foreman? No? Thank you. Thank you, Ms. Butler. Mr. Foreman, want to take it away? Do you have anything to add?
No, Mr. Chair, no, just for the record, I am Nate Foreman with the offices of O'Malley, Miles, Nyland, and Gilmore. With me this afternoon, I have Mr. Tom Conroy on behalf of NASA Federal Credit Union, Mr. Barry Kaysen with Ben Dyer as a civil engineer, and Mr. Casey Parker with Gensler, the architect. Would want to thank staff for all the hard work they've done in helping us get to this point, and we are more than happy to answer any questions the commissioners or the chair might have, and we would request and urge the board to adopt the staff report recommendations as drafted. And thank you very much.
Thank you, Mr. Foreman. Board members, any questions for the applicant? It's a pretty straightforward case. I don't have any questions either, Mr. Foreman. So if there's nothing else, is there anyone else who signed up to speak? Excuse me. for or against this case? We have nobody? Mr. Flanagan? No? Okay, so nothing else before us. So we'll close this, and board members, what's your pleasure?
Mr. Chairman, I move that we adopt the findings of staff and approve SDP-8804-02 and TCP2-013-08-01, along with the associated conditions as outlined in staff's report.
I'll second the motion.
Good motion, second. Is there any further discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
I'm going to abstain from the vote.
Okay. And I will vote aye as well. That's 2-0. So I want to check on our process, Mr. Warner. We have a quorum, so we have enough commissioners to convene with a vote of 2-1. Is that an adequate vote, given we have a quorum?
Yes, you have a majority.
Okay, so majority of those who voted, thank you, Mr. Dorner. I just want to clarify it for the record. So the motion passes 2-0 to 1 with one abstention. And thank you all. Thanks, Mr. Foreman. Thanks, Ms. Butler, for all the work on this case. Much appreciated.
Thank you very much. Have a great day.
Thank you. So now we're going to item 6. Now we'll take the 10-minute break. So it's 12:29, and we will reconvene at 12:40 after a break.
Yes, sir.
Just saying Ms. Butler. That's all.
Oh, okay.
We are all here. We have the attorney representing the attorney Apana, representing the applicant. Is the attorney here?
I'm not the attorney. I'm the civil engineer, but I'm here, yes.
Okay, all right, great. You don't want to be an attorney for the day, no? So we are back from break. Ms. Flanagan, are we good to go? We are back from break. Before us, this is item 6 on our regular agenda. This is DSP 21, detailed site plan 21014, 4100 Laurel Road property. We have Ms. Butler, who will be representing staff, and then Mr. Apana, civil engineer, who's representing the applicant. And let me turn it over to staff for a brief presentation.
All right. Good afternoon again, Mr. Chairman and members of the Planning Board. For the record, I am Tiara Butler with the Urban Design Section. The project before you is item number 6, detailed site plan DSP-21013, 4100 Laurel Road property, which is a detailed site plan for the development of an industrial storage yard. And for the record, this case was continued from its original planning board date on June 16th and continued again on July 7th. And the new planning board action limit date is today, September 8th, 2022. Next slide, please. This site is located in Prince George's County, Planning Area 76A and Council District 7, as shown in the orange color area on the map. Next slide, please. This site is located at the north end of Laurel Road, approximately 340 feet north of its intersection with Beach Road. The site boundary is shown on the vicinity map outlined in red. Next slide, please. The subject property is zoned industrial employment, i.e. under the current zoning ordinance as shown in red on the map and located on the left side of your screen. The subject property is zoned light industrial, I-1 under the prior zoning ordinance as shown in the map located on the right side of your screen. Next slide, please. This slide shows that the property is not located within any overlay zone. Next slide, please. This aerial photo shows the existing conditions of the property, which shows the site is vacant and does not contain any development. Next slide, please. This site contains slopes as shown with the red contour lines on the map. Next slide, please. This slide shows the master plan right-of-way. The site is not located near any master plan right-of-way. Next slide, please. This slide shows the bird's eye view of the property, which shows that the existing conditions of the site. Next slide, please. This slide shows the site plan. The proposed application is for the construction of an industrial storage yard that would be accessed from Laurel Road via a 30-foot wide entrance. This DSP proposes a 30 by 60-foot concrete pad in the northeast corner of the site to store gravel and sand with a 15-foot wide gravel access drive. There will be two 9-foot by 9-foot concrete pads to support two 8.5-foot diameter, 38-foot high portable silos for the storage of cement just north of the larger concrete pad. This site will also contain a 10-foot by 10-foot clean out pit and a microbial retention facility. The site will be unmanned and will be enclosed by an existing 6-foot high chain link fence. There's no parking, signage, or lighting being proposed as part of this application. Next slide, please. This slide shows the landscape plan. The landscape plan provided, subject with this DSP, contains the schedules and demonstrates conformance with these requirements. Next slide, please. This slide shows the truck turning exhibit and demonstrates how trucks will circulate throughout the site. Next slide, please. This slide shows a photo of the 350 barrel round portable silos. The two silos will be 8.5 feet in diameter and 38 feet high for the storage of cement. Next slide, please. And this slide shows the dimensions of the proposed 350 barrel round portable silos. Next slide, please. And with that, urban design staff recommend that planning board adopt the findings of this report and approve DSP-21014 for 4100 Laurel Road property, subject to the following conditions found on page 8 of the staff report. And this concludes staff's presentation.
Thank you, Ms. Butler. Questions for staff?
I just
No
have
question? Yes.
one minor question. What's going to be, and you may not know this, Ms. Butler, but what's going to be like the disposal of this silo when it reaches its sort of lifetime? Is that already kind of contemplated?
I do not know. That might be a question for the applicant. I am not sure.
I mean, that's a good question, but it's like, you know,
Wrapping up, hold on one sec. Let's just see if we can complete any questions for staff, and then I'll turn it over to you.
That was it on me. I can wait for the applicant to address it.
Okay. All right. Thank you. Thank you all. So now we'll move to the applicant. Mr. Apana, I hope I'm pronouncing your name right. If you have any presentation that you have, by all means, if you're just here to answer questions, then you already have the first question and you can take it away. And if you could introduce yourself.
I do not have any presentation, but I'm here just for Q&A. In terms of the disposal of the actual steel containers in the future, it will be like any other construction material. It's going to be carried out from the site and taken to a location that's approved by the county for disposal of any steel material or metal. So again, they're not any special material that needs to be considered environmentally damaging. So that's not the issue here. I'm not sure that's what your question was referring to in terms of if there are any environmental issues with the disposal. If that's okay, that is the question, then I don't believe there's any issues with the environmentally sensitive material here in terms of disposal of those steel tanks.
I think that answers the question.
Okay.
Thank you.
Yeah, that answers. So can you, for the record, if you could state your name and your affiliation for the record, just so we have it.
Sure. My name is Sri Apana. The first name is Sri S-R-I and the last name is Apana. I'm a civil engineer with Wave Civil, and I'm here on behalf of my client, Mr. Jaramillo. He could make it today.
Thank you. Thank you, Mr. Apana. I appreciate it. So if you don't have a presentation, are there any other questions for the applicant from board members? No, no questions. I don't have any questions either. I'm glad you were here. Appreciate it. If there's nothing else before us, nothing else from staff, nothing else from the applicant, Then let me turn to my commissioners and what's your pleasure on this case?
Mr. Chairman, I move that we adopt the findings of staff to include the technical corrections and approve DSP-21014 along with the associated conditions as outlined in staff's report.
Second.
We have a motion to second. If there's no discussion on the motion, I will call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 3-0. Thank you all. Thank you very much. Second to last item is item 7. No, hold on. Excuse me. Yes, that's right. Item 7. Item 7 is preliminary plan of subdivision 4-22007. This is at 9113 Baltimore Avenue. We have Mr. Heath, who will be the staff, give the staff presentation. We have Mr. Haller, who's speaking on behalf of the applicant. We may or may not have other folks speaking with Park and Planning and folks in the City of College Park as well. We'll see how it goes. But let me turn it to Mr. Heath for the staff presentation.
All right. Thank you. Good afternoon, Mr. Chair, members of the board. For the record, I'm Antoine Heath with the subdivision section. Item number 7 is a preliminary plan of subdivision for 4-22007, 9113 Baltimore Avenue. The applicant is proposing one parcel for the development of 331 multifamily dwelling units and 3,937 square feet of commercial use on approximately 3.82 acres. This application is supported by and subject to the Certificate of Adequacy, ADQ 2022-039, which was approved with conditions on August 24th, 2022, in accordance with Section 24-1904C of the subdivision regulations, and this is included in your backup. Regarding the preliminary plan of subdivision, the applicant, as well as the City of College Park, submitted additional information prior to the Tuesday 12 p.m. deadline. The applicant submitted revisions to conditions that can be found in the additional backup as applicants Exhibit 1 and 2, and these revisions will be discussed during the presentation. City of College Park submitted findings and recommendations that can be found in the additional backup is City of College Park Exhibit 1A and 1B. Slide 2, please. The site is located in northern Prince George's County within Planning Area 66 and Council District 3. Slide 3, please. More specifically, the subject property is located on the east side of Baltimore Avenue between Cherokee Street and Delaware Street. Slide 4, please. In accordance with the current county zoning ordinance, the subject site is located in the local transit-oriented edge zone. The properties abutting the site are located in the same zone, as well as the residential single-family 65 zone. The adjacent zones are the AG, ROS, NAC, IH, and RSF-A zones. This application was reviewed in accordance with the Pryor County zoning ordinance and subdivision regulations. In the Pryor County zoning ordinance, the subject site is located within the mixed-use infill zone. The abutting properties are located in the one-family detached residential and multifamily medium-density residential zones. The adjacent properties are also located in the mixed-use infill and one-family detached residential zones. And adjacent zones are the ROS, OS, RR, and I2 zones. Slide 5, please. Under the Pryor County zoning ordinance, the subject site is also located within a development district overlay. Slide 6, please. This aerial photograph shows the site in context with the surrounding improvements. The properties to the north beyond Delaware Street consist of mixed use and office development. The properties to the east beyond 48th Avenue consist of single-family detached development and institutional and multifamily residential development abut the site. The properties to the south beyond Cherokee Street consist of townhouse development and vacant land. And the properties to the west beyond Baltimore Avenue consist of commercial and multifamily development. Slide 7, please. Next slide, please. Thank you. The site map shows the topography of the property, which slopes downhill to the east. Thank you. You can go to the next slide. Thank you. The subject site abuts master plan right-of-way Baltimore Avenue, which is designated as a major collector and highlighted in blue. Arterial right-of-way University Boulevard can be seen to the south, highlighted in red, and collector right-of-way Rhode Island Avenue can be seen to the east, highlighted in green. Slide 9, please. This is a closer look at the site and its current condition. The site is currently occupied by commercial development fronting on Cherokee Street to the right of the screen, Baltimore Avenue at the bottom of the screen, and Delaware Street on the left, all of which will be removed. Slide 10, please. This is a look at the preliminary plan of subdivision, which depicts the property boundary in red with existing and dedicated rights-of-way highlighted in blue. There are 2 proposed points of access into the site and 1 access point out of the site. One from Cherokee Street to the right for primary access, and one from 48th Avenue at the top of the screen for service vehicles, as well as move-ins and move-outs. The applicant has also proposed a right-out only access point to Baltimore Avenue. The applicant has proposed revisions to condition 3 to include the total amount of dedication needed along Baltimore Avenue, US 1, and Delaware Street. This can be seen in applicant's Exhibit 1, and staff is in agreement with the proposed revisions. The applicant is proposing to meet mandatory parkland dedication requirements with on-site recreational facilities. This is detailed on pages 5 through 6 of the staff report. The applicant is proposing deletion of conditions 1A and 7 of the staff report, which requires a fee in lieu in addition to on-site recreational facilities. The applicant has provided an updated list of conceptual recreational facilities to be provided, which can be found in the additional backup as applicant's Exhibit 2. The list of recreational facilities will provide a variety of year-round activities for residents with varying interests. In light of this additional information, staff is in agreement with the proposed deletion. Subject site is exempt from the provisions of the Woodland Conservation Ordinance, as the property contains less than 10,000 square feet of woodland and has no previous tree conservation plan approvals. However, the applicant has proposed conditions 4F and 4G to preserve a specimen tree on site, as well as specimen trees on adjoining properties, as recommended by the City of College Park, and staff is in agreement with the proposed revisions. The City of College Park provided a cover memo along with a review and a recommendation. This can be found in the additional backup as City of College Park Exhibits 1A and B, and the city's findings and recommendations are consistent with staff's. Next slide, please. The applicant submitted a variation request from section 24-122A of the prior subdivision regulations, which requires a 10-foot wide public utility easement along the frontage of public rights-of-way. This has been requested for the right-of-way of 48th Avenue. This area is highlighted in yellow. This variation request has been evaluated in accordance with the associated provisions of approval detailed on pages 9 through 11, and staff recommends approval. Slide 12, please. Staff recommends that the planning board adopt the findings and approve preliminary plan of subdivision 4-22007 and variation requests from section 24-122A, subject to 11 conditions in the staff report and the proposed revisions to conditions in applicant's Exhibit 1. This concludes staff's presentation.
Thank you, Mr. Heath, for the presentation. Questions for staff before we turn to the applicant?
Yeah, I want to know from Mr. Heath. So one of the changes that you had mentioned, I think, involves a disagreement about the parkland fee in lieu. Can you explain that a little more? My understanding when I was reading the materials is that staff was kind of caught up in a pool as being like one of the higher cost facilities that was only going to be operational for a part of the year. Maybe that's going to be operational the whole year. But I think one of the other aspects of it was to have more access to the general public. So that way it's not just private kind of recreational facilities that might not be as good as nearby facilities like the park that's a couple of blocks to the east. So can you sort of explain the rationale around that?
Yes, so with the applicant's acceptance submittal, you're required to provide a list of conceptual recreational facilities that are going to be provided. And in the applicant's original list that they submitted, they only submitted the outdoor amenities, which staff took issue with because we wanted to see a more comprehensive list of both outdoor and indoor facilities that can be used year-round. And the applicant provided that additional information to us, which is in the backup. Regarding public access, the code allows applicants to meet the mandatory parkland dedication requirement with private on-site facilities. So staff felt that what the applicant provided was reasonable with or allowable for what's required within the code. There are provisions or recommendations in the sector plan that recommend, plazas or things like plazas that can provide access to the public, but sector plan conformance is something that's reviewed at the time of detailed site plan. So, and our urban design section, they provided that recommendation within the staff report that that's something that be considered at the time of detailed site plan.
Okay, do we know, and maybe I can just wait for Mr. Haller to clarify, but do we know of the list of items that they provided, which ones are going to have any public access, if any of them? Because some of them say like exterior, like outdoor pool and stuff like that, but it wasn't very clear to me if it's all private use or if it's public use.
These are all private facilities.
Okay, so none of the recreational facilities would have any kind of communal public use then?
No, they would not.
Okay, thank you.
Thank you, Commissioner. Commissioner Washington, any other questions for staff? No questions for staff. We turn to the applicant, Mr. Haller. If you can introduce your team and let us know how you want to proceed. I don't know if you have a presentation or you just want to be available for questions. I'll leave it to you. So take it away.
Thank you so much, Mr. Chairman. Again, members of the board, for the record, Thomas Haller, an attorney with offices in Largo. And I'm here today proud to represent RST Development on this project on US 1 in College Park. With me today are Scott and Danny Copeland, who are with RST Development. And we also have our engineer, Shonda Beaufort, with Bike Engineering on to answer any questions. I do want to just start by saying that we have worked very closely with the City of College Park as well as your staff. I want to thank Mr. Heath for working with us on the application as well as the conditions. And I wanted the board to be aware as well, and I know that Miriam Bader is on the line as well. But we worked closely with them to make sure that we coordinated their conditions with the county's conditions. And so the revised conditions that you see before you incorporate the conditions recommended by the City of College Park that were not in the initial staff report. And so the revised conditions address both municipalities' issues as well as the staff issues. And so with those changes, which staff has indicated that they are in agreement with, we are in full agreement with staff on all of the conditions and the wording of the conditions. I would like to point out a couple of other elements to answer Commissioner Dorner's question. All of the facilities that we are proposing are private facilities. There are recommendations in the sector plan for outdoor seating like benches and streetscape improvements, which will be addressed at the time of detailed site plan. I would also like to note that the property which RST is purchasing includes land on the east side of 48th Avenue, and that property currently is improved with a house. Our plan, that property is not within the boundaries of the DDOZ, but our plan is to remove the house and allow that property to serve as a buffer to the existing residential community. The City of College Park has indicated a potential desire for us to dedicate that property to the city and for the possible improvement as a public pocket park or some other recreational facility. We are open to doing that. And there's a condition that the city recommended that we will work with them to discuss that with the city to determine if there's interest for that property to be dedicated to them. And as I said, we're open to doing that. So as of right now, the recreational facilities that we're proposing, the external facilities such as the pool, the dog park, the outdoor sitting area, et cetera, those areas are private, but there is a potential for a public access to the other property should the city decide that they want to take it. So we think we've fully addressed the provision of recreational facilities with regard to this project. Did you have any further questions specifically with regard to that?
No, I think that helped because I was also going through the memo and the staff reports from the city of College Park, and knowing that you've covered those and that they're in full agreement, I think helps. So thank you. I do have a question, but I can reserve that for a couple more minutes down. That is just kind of minor.
That's fine. And the other thing I wanted to just highlight very quickly is that, Mr. Heath mentioned that we have a certificate of adequacy. The southern boundary of the site is Cherokee, and we did our transportation analysis, and it showed that Cherokee operates at an adequate level of service after total development is considered. But the city asked if we would add a right turn lane onto US 1 to improve the flow of traffic on Cherokee. And even though it's not technically required to meet adequacy, my client has agreed to do that because it does improve the flow and it makes this a better project. And so we've agreed to do that. And that is a condition of the certificate of adequacy. Also, a condition of the certificate of adequacy are crosswalk improvements. And I heard you comment earlier about safety of crossing Route 1, particularly in the North College Park area. And so we worked with the city to identify bicycle and pedestrian improvements based upon a study that the city had performed. And so all of our BPIS improvements involve upgrading pedestrian crosswalks in the vicinity of the project. And we're pleased to make those improvements because they will improve the safety of crossing Route 1 and other local streets for both our residents, but also for everybody else that lives in the general neighborhood. I do want to note that this project is really exciting because it's going to result in two very positive impacts. The first is that the project will result in the redevelopment of 3 motels that have long outlived their usefulness in the Route 1 corridor. This is a really good example of how the sector plan for Central US 1 encourages redevelopment. And this project will help to implement the vision of the Central US 1 corridor sector plan by eliminating these older, dilapidated commercial uses and replacing them with a modern a building that will contribute to the community. One of the ways that this will contribute to the community is that the project is proposed to be an affordable non-student housing project. And with that regard, Mr. Scott Copeland with RST has considerable experience in constructing affordable housing. And I'd like to have him address the board briefly about what RST's goals are for this project. Scott, I'm going to turn it over to you.
Thank you, Tom. Good afternoon, everybody, and thank you very much for the time. And I will indeed be brief. Obviously, you've had a full morning / early afternoon already. I am Scott Copeland. I'm with RST Development. I'm a principal of RST. RST is a now 3rd generation family owned and operated business. And we have had, as Tom mentioned, considerable experience in development of all sorts, but in particular with affordable housing. And this project will fit that mold perfectly. We are proposing to finance this project with a federal tax credit, which I'm sure you're all familiar with. It's a low-income housing tax credit, which is administered by the state of Maryland. And this project will support and be available to households that earn 60% or less of our area median income. The demand, as you can imagine, is extremely high for this type of product, especially at a location like this. So we are indeed excited to bring this project to the market. Over the years, we've developed somewhere between 8,000 and 10,000 apartments in the last 30 years or 25 years since I graduated from the University of Maryland. and happy to be back in that community. The majority or a good portion of that development was with some sort of subsidy or some sort of affordability, typically with the low-income housing tax credits. We've done this several times in the state, throughout the state, a handful of times in Prince George's County as well, and have a very good working relationship with the state and feel very confident that we will be successful in getting the financing available. Our latest project, and which I will close on, is a project that we did much smaller scale than this, but I would offer equally, if not more, impactful to the community. And that is a project called Main Street in Rockville. It's in the Rockville, Rockville Town Square. And Main Street is a affordable and inclusive apartment building with about 10,000 square feet of community space that serves all portions of our community, all segments of our community, with a special slant to people with varying special needs. And the magic of Main Street is the programming that it includes, the embodiment of community. And our nonprofit partner in that project, which is called Main Street Connect, which is run by my wife, has 20 plus programs a week for not only the residents of the building, but also for members of the community that want to join in these varying programs. So we look forward to continuing that embrace of community in this project by partnering with Main Street and others that will really enhance not just our property, but we feel strongly will enhance the community. So we are grateful and thank you guys in advance for your consideration of this project, but we look very, very much forward to moving forward with this development. Thank you.
Thank you, Mr. Copeland. Mr. Heller, you're on mute.
Thank you, Scott. And with that, I have nothing more to add. I'm happy to answer any questions and welcome any questions that the board may have of both myself and Mr. Copeland.
Right, thank you. Questions for the applicant, any members of the team, the developer?
I have a couple minor ones. If I can ask those. Mr. Holler, so thank you for paying attention to earlier. You can probably guess that part of my comment was because I know you have a few projects in that area and you'd be listening to some of the comments about just pedestrian activity on Route 1. So one thing that I think is still a problem with the intersection at, is it Copeland that's the one that's on the south side of it?
Sure.
Cherokee. Yeah, so the sidewalks there were not aligned, or at least they might have been fixed, but they haven't been aligned for a while. So as you're trying to cross over that intersection, you have to go kind of a diagonal. And if you can kind of work on maybe making sure the crosswalk there is visible with like the piano key or other kinds of crosswalks, I think that would be really helpful because it's not obvious as you're walking across there if cars are coming in that you're actually walking to the other sidewalk just because it's not necessarily totally straight right there. The other thing I wanted to ask, I'm glad that Mr. Copeland, you talked about the affordable housing aspect, because I think getting the housing in that actually is affordable is very helpful to this community, because a lot of the times we hear projects that are just 100% of AMI, which is fine. It fills a need, but it's not affordable. By no metric is that affordable by any kind of public policy that's out there. Usually you look at like 60 to 80% at the highest kind of AMI. So I was happy to hear about that, because it's filling a gap that we don't often get. And thank you for doing that. I did want to just find out on the Main Street Connect that you mentioned an aspect of folks with like special needs or just kind of alternative needs. What is the target group for that, just out of my own curiosity?
Specifically at Main Street?
Yeah.
Yeah, so Main Street was financed with similar financing, low-income housing tax credits. That deal was a 9% allocation. We're proposing 4% on the project in front of you. And 25% of the units at Main Street were especially designated and set aside for individuals with varying special needs. And that's the spectrum of needs. Some may very well be on the spectrum. My son lives there. and he has developmental delays, for example. So he has many aspects of his life. He's very independent, and others not so much. So it's sort of a wraparound community, and a large portion of the individuals that qualified for those units are in have similar needs. If that answers your question.
Yeah, no, that's why I just wasn't sure what you were referring to for special needs. My daughter has as well. So I'm very happy to see those kinds of options. My brother does as well, and he lives in subsidized housing in a different state. So it's good to see that kind of outreach helping here in our own community, because it gives kind of at least hope that if we continue to live here for a long time, that my daughter will have potential options for independent living. So thank you for continuing that push. And that's it.
Thank you, Commissioner Dorner. Commissioner Washington, any questions? No questions. The only thing I would say, Mr. Copeland team, Mr. Howard, I've joined with Commissioner Dorner. It's really commendable, the project that you're taking on. I'm glad this is all affordable. This is a very, very important addition to the Route 1 corridor. You know, a whole lot of market rate housing, a whole lot of student housing, which we love, and this is a missing piece. So I'm glad that you're doing it. I've just all sorts of questions that aren't related to this approval, related to how you're managing the financing and making the deal work, and some of this will come out, you know, later in the process at how you amenitize it, and you know, what the building design is going to look like. Is 4% deals. I mean, it's not as bad as a 9% deal, but it's hard to make the numbers work. And so it's nice to see that you're committed to doing an all affordable deal and still providing all these amenities. It really is. I guess one question I have is, how closely have you worked with the county executive's economic development team on making this project happen?
We have yet to really approach the executive branch of the county yet. We were anxious, candidly, to get through this process. We have a very affable and friendly seller, but you know, nonetheless, you know, these are challenging times. So we sort of crawl, walk, run. We have applied for our financing, and actually, you know, literally on my list sitting next to me, the next thing to do is to have that outreach with the county housing folks and other parts of the administration. So
I just think they're going to be pretty excited about this one, and it's commendable.
I hope so. Thank you.
Yeah. So I've got no other questions. Commissioners, if there are no other questions from you, is there anything else from staff? Anything else from the applicant? Anything from the City of College Park?
Yeah.
Yes. Good afternoon. This is Miriam Bader, Senior Planner for City of College Park. And the City Council met on Tuesday night, and they voted unanimously to support RST, the preliminary plan, with the applicant's revised conditions.
That's wonderful to hear, Ms. Yeah, thank you for all. I mean, I know that we're hearing this for a few minutes. I can only imagine the weeks or even months of work that has gone in, the conversations that have gone on to make this happen. And so I commend you, City of College Park, Ms. Bader, on behalf of the city and staff as well, for all the work that you've done with the applicant to bring it to this place. So thank you. Thank you very much.
Thank you. And I commend Tom Haller and his team and the applicant for working very well with the community and meeting with everyone and working with staff. So I want to thank them.
Great to hear. Okay, so if there's no other questions, commissioners, what is your pleasure?
Mr. Chairman, I enthusiastically move approval that we adopt the findings of staff and approve preliminary plan 4-22007 and variation from section 24-122A, along with the associated conditions as outlined in staff's report and as further modified by applicant exhibit number 1.
And I will enthusiastically second it.
I will enthusiastically ask if there's any further discussion on the matter. If not, I will call the roll. Commissioner Washington.
Vote aye enthusiastically.
Commissioner Dorner.
Vote aye emphatically.
I will vote aye as well and associate myself with the enthusiasm of my colleagues. Thank you for the excellent project, and we're looking forward to seeing it move forward. So this case is approved 3-0. Thank you very much.
Have a great rest of the day.
Thank you all. So we have one final item before us on the agenda, which is item 3A. Item 3A are legislative items. We have 4 bills before us. No, we have 5 bills before us. Is that right? Ms. Hightower?
Yes, Chair.
So you've been, we're standing between you and lunch, Ms. Hightower. So
Okay.
thank you for your patience with us.
Okay.
And let me turn it over to you. I think in terms of process, we've got 2 bills that that are essentially policy bills, and you're recommending that we take no position on them.
That is correct, Chair.
Let me ask you to go first with those, and just we'll get those out of the way. That would be 76 and 80. And then I'm going to switch the order around a little bit because the more complicated one, I believe, is CB 77, right?
Yes.
So let's do 76, 80, then we'll do 78, 79, and we'll end on 77.
Okay. CB 76 amends the non-residential transit-oriented activity-based zones and the planned development town center zone regulations to require special exception approval for gas station. The bill also adds additional special exception regulations, which are outlined in the staff report. I can go through those if the board should like. The district council may also consider the number of proposed existing gas stations when making a decision on whether another gas station should happen. The proposed legislation, as Chairman Shapiro mentioned, is a policy decision to be made by the district council to require special exception approval for gas stations. Staff does not have any administrative issues with implementing this legislation as drafted. We did make a recommendation that the district council add a specific special exception finding language to the bill for to the bill to state whether a gas station is warranted. We also asked that staff that the district council revise the bill to add all principal use tables and remove any language which provides use-specific standards for when the gas station was permitted by right. And that concludes staff's presentation. Thank you.
Thank you. So on this bill, staff's recommendation is that we take no position on this. And again, this is a policy bill. And the only thing I would say in discussion, in advance of this discussion, essentially gas stations as special exceptions has been the direction that we've been heading in the county for years and years. And this is really the last zone where where gas stations aren't special exceptions. So this is sort of the tail end of a process that's been going on for a while. Am I capturing that correctly, Ms. Hightower?
Well, under the new zoning ordinance, in these zones, we had them permitted by right because they are a special exception in every other zone except for residential zones where they're prohibited. But this will, of course, as you said, Chairman, require special exception approval for all gas stations. And
essentially, gas stations will only be allowed by special exception anywhere in the county at this time.
That is correct.
But staff's recommendation is that we take no position on this with this amendment because it is a policy bill. Director Checkley, you have something to add?
I just want to point out a general concern that we have with a lot of these bills. You know, the new zoning ordinance just went into effect and already we're getting all of these changes. I don't know, I can't find out or tell if it was simply a mistake that they didn't want these permitted by right in the zone. And so this is a cleanup bill, or this is a change from what was decided when the new zoning ordinance went into effect. That's my only concern.
Thank you. I appreciate that. Board members, staff recommendations that we take no position on this with an amendment. So we're taking no position, but we're having a suggestion around what they should be considering per your direction. So questions for staff on this? No questions? Let's take these up one by one. So what's the pleasure of the board on this one?
Move that we accept the recommendation of staff and take no position with the amendment for CB 762022.
Second.
Okay, motion second, I concur. There's no further discussion on this. I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Joyner.
Vote aye.
I vote aye as well. Ayes have it 3-0. Thank you all. So next we'll go to CB 80, which is the other policy bill. Sponsors Councilmember Medlock and Ms. Hightower, take it away.
Yes, this bill amends the definition for a convenience store to limit the percentage of tobacco products, electronic cigarettes, and other electronic devices to be sold in a convenience store. The bill also prohibits a convenience store from being within 2,000 feet of another tobacco shop, electronic cigarette shop, or retail business, or another convenience store that sells tobacco. Again, as previously mentioned, staff believes that this is a policy decision that the district council has in their hands to make. We did note in our staff recommendation and explanation that the proposed legislation could be a little bit difficult to enforce, and some of those items are outlined in our information that will go to the district council. One of the examples is how will there be a determination on the percentage of tobacco products that are sold in a convenience store. But we're leaving that to DPI to work out those operational issues. We also recommended, though we have no position, we recommended that all of the use tables be also added to this bill to show the new proposed use-specific standards for the convenience store. And we also recommended that a permit site plan or detailed site plan be required to show that a convenience store is not located within 2,000 feet of another convenience store, tobacco shop, and so forth. That concludes staff's presentation on CB80.
Thank you for that. Director Checkley, anything you want to add on that one? You're okay? Okay.
Just a question.
Questions?
So I should probably know all the land use categories that we have in the county, but admittedly I don't. I know that we do have like a retail tobacco shop that years ago, maybe 7-8 years ago, became kind of controversial for various aspects. Do we still have that designation, or is the convenience store the way that we would go through if you had like a smoke shop, like a cigar shop or tobacco shop of some kind?
That use is defined separately, and in our new code, it requires a special exception. Tobacco businesses, tobacco shops, cigarette, any shops that sell that. But what the issue is, I understand that a lot of the convenience stores are selling more tobacco than they are being convenience stores. And convenience stores are permitted by right in the county.
Okay. All right. Thank you.
Any other questions?
No.
If not, is there a motion?
Move that we accept the recommendation of staff, Mr. Chairman, and take no position with amendment for CB 80 2022.
Second.
With motion second, further discussion? I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Joyner.
Vote aye.
I vote aye as well. Ayes have it 3-0. Thank you. So let's take up CB 78. And then again, we'll do 79 and end with 77. So CB 78, Ms. Hightower.
Okay, this bill requires split zoned properties to develop using higher intensity zone development regulations unless the applicant decides to develop using less intense zone regulations. Staff believes that this bill would supersede the regulations that are in the current code for uses of within a less intense zone. The bill also assumes that split zone properties always consist of 2 zones, but that is not the case in the county. Sometimes properties have 3 zones zoning categories. Staff believes that any global effort to legislatively retrofit split zone properties is likely to create substantial incompatibility issues. Of course, without a case-by-case analysis of all the split zone properties, we believe, again, this will make things incompatible throughout the county. Staff also believes there may be some legal concerns with this bill, but we do defer to the council and the council's attorneys for comment on potential legal issues. We also concerned that with the legal issues that this in effect rezones properties through legislation rather than the authorized rezoning process. Staff recommends that the planning board vote to oppose CB 78 2022.
Thank you. Staff is pretty clear that this undermines the integrity of the zoning ordinance. Are there questions for Ms. Hightower or other staff members?
Have we worked with the county council members who are potentially to at least help them think through best practices in land use? I stopped doing split zone stuff and stopped doing like one-off exceptions and different things that they do that are just not the best practices for planning on a global purpose.
And let me just jump in. The short answer from my perspective is yes, because I've had these conversations directly with council members. But let you hear from staff as well for what their process has been. And Mr. Warner, I think, wants to weigh in as well. Actually, let me turn to Mr. Warner first, and then I'll turn it to Ms. Hightower or Ms. Checkley.
Thank you, Chair. Yeah, as Commissioner Dorner, so I've been here about two and 3/4 years now, I guess, and have worked to develop a relationship. This is just on the attorney side with counsel to the district council, and have rapport with them, and we do talk about legal issues, and they ask my advice from time to time, and I on my own offer it from time to time, along with the zoning hearing examiner, Ms. McNeil especially. We discuss the legal implications of bills from time to time, informally, because the planning board has the role of making the recommendation. But we do have that kind of communication going. So I can speak at least to the lawyers that we do talk, not saying that they always follow my advice, of course, and they may be better situated than I am to make decisions in certain things. But we do have dialogue to the extent of the lawyers, at least.
Thank you. Ms. Hightower, Director Checkley.
I just wanted to point out that sometimes the split zoning is intentional, especially when you might have 3 different zones on one property. You might have, low density residential on one side and industrial on the other side. And so the 3 different zones are to buffer the low density residential with, the decrease to maintain that integrity. So sometimes it's intentional.
In fact, the courts will start with that premise that the split zone was intentional. So if an individual owns 2 slices of a lot that are in 2 different zones, the courts will say, well, that was the intention. And then you go from there. Well, then how do you address that? Usually you go get a variance.
Yeah, sometimes the intention is not necessarily good-natured. And I think that's the problem. When it follows like decent practices of helping preserve some intensification and working it up so you don't have like very large discrepancies between adjacent lots, and that might be justifiable. But in instances that we sometimes see, like it's not based on professional practices. It's an arbitrary decision that's being made for political favor or whatever it might be. And what I was kind of getting at is, yeah, I realize we have with the career staff relationships with them, like on the attorney side, but we have this kind of revolving doors that come in through county council members and their own staff as they come through. And it might be helpful to have, if we haven't done it already, like staff just walk them through like, hey, here's what the new zoning ordinance is like. Here's good things that come out of this. And here's things that we've been trying to fix that have been kind of problems over the past. And of the 200 cases that have happened when we've had split zones or something, like 150 have been overturned, or things that are just kind of talking points to give them ways of understanding why it's probably not a good decision to go that way, and that we're actually being intentional about a lot of the stuff we're doing, just so they don't walk down that path of kind of arbitrary rezoning or kind of undoing some of the things that our staff are trying to put in place. And then they would know who the staff people are if they have questions, that they could go and ask them from like a staff to staff kind of a level. Hey, what do you think about this? Is this that thing you talked about a couple weeks ago that we shouldn't do, that wouldn't kind of like not be the best choice to make? Or is this okay under these sorts of situations? Or how do we get to where we want to get? Maybe might be the different kind of discussion.
Thank you for that. Other questions?
You guys
okay.
That in the future?
So yeah, I mean, I think, right.
Yeah.
My experience as staff is very much aligned with you, Commissioner. And I mean, they can speak to it themselves, but I think this is what they do. I think that the bigger issue is that, you know, there's a whole new crop coming in that we need to do a lot of education with. And I think that's part of what I really hear loud and clear with you. There's also just a different orientation, sometimes just a different will that comes from some council members, so that, you know, to be blunt, they just don't always listen. But staff, I think, is doing a pretty good job at communicating and educating, but your point is well taken.
Yeah, I'm just thinking like the new crew coming in that maybe hasn't gone through this and hasn't had like Deborah Borden's one that she goes through, or other people that would do those things. That would be really helpful to just avoid kind of split zoning, spot zoning, all like the don't do these kind of things in planning.
Yep.
Okay, that's it for me.
Thank you. Commissioner Washington, I know you're having some technical issues. We can see you fine. I think we can hear you as well. So any questions for staff?
No questions, Chairman.
Okay. Thank you. So we're, again, this is item CB 78, 2022. Is there a motion?
I move that we accept the recommendation of staff to oppose CB 78, 2022.
Second.
Motion is second. Discussion. Call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. Ayes have it 3-0. Thank you all. So next we have item CB 79, 2022, also sponsored by Councilmember Franklin and Ms. Hightower. Take it away.
Yes, this bill reduces the lot coverage and green area requirements in the IE zone properties that were previously zoned I1. The bill will also permit distribution warehouses in the IE zone by right without special exception, which is currently required, if the previously zoned I1 property is undeveloped. CB 79 creates large inequities among owners of IE zoned properties and greatly erodes zoning principles. During the zoning rewrite process, the council wanted to ensure that vacant properties which had no prior approvals or pending applications would use the regulations of the new zoning ordinance. It's only been 5 months since we've had the new zoning ordinance, which is an insufficient amount of time to propose such a bill that would make such significant changes to the county zoning. Planning department staff is also committed to the district council to comprehensively review the IE zone, its table of uses and the uses that are listed in the table of uses, to create a substantive bill in the future. We also point out numerous formatting concerns with the bill, and those are outlined in our staff report. Staff recommends that the planning board vote to oppose CB 79, 2022.
Thank you, Ms. Hightower. Let me just say, I'm regardless of the intention of the council member, giving him the benefit of the doubt on this, but from staff's perspective, in my own read on this, I agree with your concerns that this erodes the zoning principles of uniform application of zoning laws within zoning classifications. This bill would undermine the integrity of the zoning ordinance, clear as day. So, yeah, I won't be supporting this one. I don't know if you have any other questions, council members, on this one, or not council members. I apologize. I would say promoted, maybe demoted you. I'm not sure, depending on my mood. Any questions?
No questions, Mr. Chairman, but I associate myself with your comments and move that we accept the recommendation of staff and oppose CB 79, 2022.
Second.
The motion and second. If no discussion of the motion, I'll call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
Vote aye as well. Ayes have it 3-0. Thank you. So now we'll go with CB 77, 2022.
CB 77. This
Your favorite bill.
Yes. Let me mention before I start that the PHED committee met yesterday, and they did vote the bill out of committee. We did take staff's comments.
On a split vote.
Yes, they did. And we're going to look into how proposed draft 2, if you will, and give them some additional feedback on that. But telling you what CB 77 draft 1 is about, the bill drastically alters the transitional regulations added to the new zoning ordinance in 2018 and in 2021 through revisions. There is considerable collaboration between the county council staff, zoning hearing examiners, county executive staffs, MBIA, the land use board to develop the current transitional regulations. As you know, these regulations were developed to manage pending, completed revisions to approved applications under the old zoning ordinance. Staff has concerns that this proposed bill allows development projects that were constructed under the old zoning ordinance to use the old zoning ordinance no matter the circumstances forever. The existing transitional regulations require development applications to be in process prior to April 1st, 2024 to use the old zoning ordinance. So we do give a transition period currently for projects that want to be revised or do different things to. The bill also extends exemptions from the new code for changes in ownership, changes in use and occupancy, and makes uses in the old code available in the new code forever. Staff says that these regulations will create interpretation issues. There will be budget issues because staff will forever have to manage 2 different zoning codes. We also believe that it is premature to propose such a broad and far-reaching impactful bill. Again, as I mentioned during the discussion of the other bill, it's only been 5 months that we've had our new zoning ordinance. So staff recommends that the planning board vote to oppose CB 77, 2022.
Thank you, Ms. Hightower. Questions on this one is about as clear as day, but I certainly want to see if there are any questions from board members on this issue.
No questions, but and I think it goes to the heart of Madam Director's comments at the beginning. It's just what and why. I mean, it's only 5 months. It boggles the mind that, the ink isn't even dry on the new zoning rewrite, and we've got this plethora of bills that keep coming through.
Yeah, I'm with you. So if there's no further questions for staff, I associate myself with Commissioner Washington's comments for sure. Is there a motion?
Mr. Chairman, I move that we accept the recommendation of staff and oppose CB 77, 2022.
Second.
Motion is second to oppose. Discussion on the motion. Call the roll. Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
I vote aye as well. The ayes have it 3-0, and we will ask staff to keep us in the loop with all these as they progress, as you always do. That concludes all the items for, thank you, Ms. Hightower. Thank you, Director Checkley. That concludes all the items for today's agenda. I want to thank staff and all the others for your participation today. Mr. Hunt, is there any further business to come before the planning board?
Now, Mr. Chair, there are no additional business items before the planning board today. Thank you very much.
Thank you, Mr. Hunt. So without objection, we are adjourned. Thanks, everybody.